What's up, everybody? Hope you're doing well. It's, of course, Andrew Esquire here, Legal Minds, where we teach you to be your own judge. Up early in the morning here in Seoul, South Korea, ready to rock and roll with this case. Just came over from Legal Vice's channel. He should be headed over here with a lot of his peoples very soon. And good to see all y'all in the chat, because we're getting started today with the Murdaugh trial and with opening statements. And this will be the most based and unpretty coverage there is on the internet, period. That's it. Best chat, best everything over here on this channel. Good to see everybody in the chat piling in here. What's going on? JG, Mike, Pete, Nikki, Bias Confirmations, Natalie, Brenda, Julian, Lele, everybody, Patrick in the chat. Good to see everybody over here. Darth Holler, what's going on? Glad to see you made it, brother. Good. Merms. Oh, shit. It's Merms. Good to see everybody over here, especially the people that are early. I appreciate that. And also, if you guys want, you can follow over on Locals and over on Rumble. And shout out to everybody who's over on Locals, all the degenerates there. If you want to share any memes, the best place to share them with me, if something hilarious happens, come over to my Locals. I'll post the link in the chat. You can join that. Drop a meme in there. You can still follow along on Rumble or Rumble or YouTube if you want. But hey, if you got Locals, you got something funny, you got something you want to share, drop it there. I'll check that and try to pull it up when we get a chance, when we get a trial break. But good to see all the folks over there. And yes, of course, we've got Rumble as well. And I will actually, I'll post the Rumble link on YouTube as well. Don't tell YouTube. What's going on? The people piling in here, right? Murdaugh, Annette, Anna, Gemma. Good to see y'all over here in the chat. So we're gonna start out. We've got the coverage. So just so you know, I am watching the coverage. It's pulled up in the back. So we've got this right here, ready to go, locked and loaded. Whenever it starts, well, I believe we're gonna have the coverage starting in about an hour. Actually, right now, probably about 40 minutes. We're going to have opening statements start up. We may have some preliminary motions, but I imagine those motions won't take too long. If we do have preliminary motions, maybe, could be like 30 minutes of motions max, and I think we'll jump right into at least the prosecution side of the opening statements. And then we also, I know that y'all who are over on that Vice Squad, you guys were watching the motion hearings. We will be checking those out and picking up where Vice's left off. Good to see that it worked. Good to see that the baton handoff worked. Sometimes it doesn't work, but good to see it does work. And one person that does work, and he works really hard. In fact, he works so hard, he doesn't sleep and kills 3.5 liters of whiskey a night. That is my good friend, Jeff, Legal Vices. How's it going, brother?
Gee, long time no see.
Wrong time no see. Yeah, good to see it worked. Good to see the handoff worked.
How many people made it?
And good to see everything. Also, Uncivil, I thank you for your very kind message. I want to go out and promote kindness, right? Because Uncivil was very nice, and he said, "Hey, I know you're streaming this. He's trying to stream this as well." He said, "If you happen to be available, pop over." I said, "That's very nice. Same goes to you, brother. Anytime you're welcome. You're welcome in the chat." And for all those that know, I've said this too. Anytime that I conflict with streaming with anybody, it's nothing personal. It's not because I don't like him. It's just because I felt like I wanted to stream that particular case. That's pretty much it.
Well, last night during the boring back and forth with all this jury selection, Kurt and I, we stream sniped each other for a little bit.
Totally
sent messages back and forth.
Yeah.
So yeah, we had a little bit of fun with the boredom that we were all faced with yesterday.
All going through. It's a shared problem. And as we go through this case, we deal with frustrations, bullshit. We'll each vent in our own way. That may be Vices and I drinking. That may be whatever else is going on. There may be, shots fired at the North Korean border. Who knows? Who knows what's going on? But all right, I think what we had, and correct me if this is wrong, Jeff, but I think you were watching some preliminary motions.
Yes.
And you were watching that right before you started, and I believe this was the timestamp. It was 1:39.
Looks right about there. Yep.
Okay, cool.
These are the two guys in the Muppet Show that hang out in the box seats, the janitors.
They really do look like the two Muppets. What is it that who are the two Muppets? Oh my God! Now I
can't think of it. It's like Statler and Waldorf.
Statler and Waldorf. So these guys literally do look like Statler and Waldorf. I'm not going to lie about that.
And Dick Harpootlian over here on the left is a state senator who has extensive murder and death penalty case experience.
Okay, this guy is Dick Poon. All right, so Dick Poon, and I'm just going to say it. I'm going to say it. I know we're not 2 hours in yet, guys. 5 minutes in, but I mean, it's Dick Poon. What can you say? And what's not to love about Dick Poon? Except for the fact that he's probably a dirty senator.
dirty senator.
Yeah. By the way, do they limit the amount of people in the courtroom? Because they're not even. Has no one commented on this? That they've got so many empty seats here.
Well, it was filled with jurors before, and then they took all the jurors out and did the motions.
Well, these are not the jurors. Obviously, these are not the jurors here. And I know that
this is probably the defense team.
That's true. That could be solely the defense team in the courtroom. I know my good friend James from court is actually there, and he should be popping on at some point during this to give some updates. He's a real good guy. So I expect to see this by the time this kicks off during opening statements. I expect to see this full. That's my thought on this. But let's kick this off and let's hear these motions.
Not consistent with the state of the law, not consistent with my experience, and I understand, Attorney General has not litigated a lot of
that is
cases.
Exceptionally loud.
Since
exceptionally loud. All right, let me see if I can take that out. Maybe that's.
I backed it off about 1/3, about a quarter to 1/3 is where I backed it off to.
You backed it off. You backed it off a quarter. All right, I'll back it off on their end a little bit. Yeah, let's do it. Let's try that because I usually up it on my end.
Wow, I'm sorry if that's how loud it was for people.
More than just net worth in a punitive damages case. Never have gotten it. The last point I make is this.
It must be a hot mic.
His theory, and this is sort of, is that he knew the jig was up, so he went home and blew the head off his son, and butchered his wife. There's not one shred of evidence there was any problems between any of them. There's texts, pictures, people that were with him the previous weekend at a ball game, video from that day with Paul and he having a good time. There is no dispute anywhere that they were the perfect family in terms of their relationships. No divorce, no separated, no left him, no nothing. So this is a fabrication, and they want to use what Mr. Griffin described as bad character evidence. He stole all this money, so he must have killed his wife and son.
Yeah, the closed captions are epic.
As he cited, there are at least 6 South Carolina Supreme Court cases.
Yeah.
I may be over.
Jew roars.
How many?
Jew
roars. Four South Carolina Supreme Court cases disallowing, and judges will reverse, disallowing this kind of evidence. Now, if they've got some evidence that Maggie was getting ready to turn him over to the feds, or Paul knew about it, was getting ready to talk about it, or he'd been threatened by them, certainly those cases say that's when that kind of stuff can come in, but not this theoretical, we ain't got a motive, we're going to make one up motive. That is
what I'm getting from you, both of you now, are you give me jury arguments, and you're arguing.
I like this judge.
I do like the judge.
Simultaneously. Regarding the motion by the state for me to grant an in limine motion admitting evidence, that's what you're seeking me to do. And you in your motion, you indicate that the basis for this is for judicial economy, that there may be no precedent for the court ruling in advance of any testimony, granting in limine the admission of motive as evidence during the trial. You seeking to have me do that?
Well, Your Honor, I recognize what the court's saying. I think the first issue with that was in response to the defense bill of particulars. And our response to that was, they essentially asked, they said, tell me what financial evidence you want to go into. And so we responded by saying, well, that's not recognized under South Carolina law, but we filed this particular motion.
I understand all that, but typically a motion in limine is a motion to exclude evidence.
That's correct.
Your motion in limine is for me to admit evidence. And
That's kind of the opposite of a motion in limine.
Yeah, that's not a, and we can, and since this is already played, we can pause this for a second. That is definitely not a motion limine because it's not limiting anything. It's pretty much having the trial in front of the judge instead of the jury, which is what you don't do. What you don't go into is fact finding during a preliminary motion, which I think is what they're trying to is what they're trying to do here. By the way, just my initial take, yeah, definitely like the judge.
Good guy.
The defense team seems like they're going to be interesting because there's so many of them in the tag teaming. I mean, this seems like Marvel versus Capcom, where you slap the hand and they come in and they objection. So it should get. I expect this to get fairly ridiculous pretty quick.
And I want his chair. That's a nice chair.
Admit evidence through a motion in limine.
Well, and of course, in our motion, and stand by for me, Your Honor, just 1 second.
Oh, Sheriff, she woke up. That's good. She was asleep for a while. She was just nodding. She was just nodding off in the background
I
there.
recognize that typically a motion in limine is to exclude evidence, but the cases that we cite and the language we cite in our motion, of course, is to prevent disclosure of potentially prejudicial matter to the jury, and of course is traditional and subject to the actual evidence being offered. And so the point.
And by the way, I want to make a point here too, and actually we can make this point. So someone says motion in limine requests the court to limit the admission of certain evidence, which is true, but also it can be a motion in limine can be to allow the evidence, right? To allow certain types of evidence to be admitted. However, it doesn't actually admit the evidence, right? It just allows the admission of the evidence. There's a difference there. I know it sounds like it's the same thing, but that's actually different. It's saying, hey, we're going to offer this. We want you to acknowledge that we're allowed to offer this type of evidence because we found XYZ. There's certain types of evidence that you can only admit if certain elements are present. So you'd make a motion in limine to present that. You say, hey, we think we've met these elements. We're going to admit this type of evidence. And you could address it at motion in limine. So just to clear that up. Jeff, do you have anything else about motion in limine in general?
That's about it.
Okay.
Because it's very extensive and because we realize that this case is different. As I've argued, this case is much different than any case we've ever seen because of the complexity of all these factors going together. And I think essentially what we were trying to do is at least get some sort of preliminary guidance, understanding that evidence will have to be developed at trial as to the admissibility of this. Now, ultimately, if the court is more comfortable with having in-camera proceedings as to the admissibility of evidence, then I understand that, and we can do that as the case develops, as we were talking about the other things.
Well, this will create a mini trial, given all of the various offenses, 90-something allegations. And of course, we also deal with the issue of res gestae, issues of matters that may be too remote in time and the like. What I'm grappling with is your request for me to grant the in limine the admission of evidence. I frown upon motions in limine, period, because I don't know the facts.
Oh, that's interesting.
I do not know the facts.
Yeah, that's a position.
I know what you all have submitted in your briefs, your arguments. And
Dude, that's a let all the evidence in and let God sort them out
opposite
guy. I like that.
That's why we have testimony, and judges are to rule not based on lawyers' arguments, but based on evidence. And I am not prepared to grant in limine a motion admitting evidence, though it may be admissible under the same theories that you have promoted. I agree with the authority and the rule that allows for motive to be admitted in a case under appropriate circumstances. And your all's argument in the cases cited by the defense, some are remotely similar in facts, and most of them are dissimilar. Each case must be decided on its own facts and circumstances. I believe that the Siegel case is persuasive authority, U.S. v. Siegel. Though in that case, very noted jurist who spent some time in our state was reversed by one of our noted jurists, Judge Traxler, on the same issue. But I'm not prepared to grant admitting evidence in limine. It must be done during the course presentation of evidence during the trial.
Absolutely understand that, Your Honor. And again, I recognize that we were attempting to perhaps identify those issues and bring those issues because of the complexity of everything to the court's attention. And I certainly understand and recognize, and that's the typical manner in which we would do that, is to have those issues addressed as we move through the trial.
That deals with that issue.
Thank you, Your Honor.
That leaves a ballistics issue.
So what do you think about that, real quick, Jeff? We'll get a little ongoing analysis here. What do you think about not allowing motions in limine and just saying, hey, we're not going to allow these. We're just going to say as a type of thing, we're gonna exclude these. How do you feel about that? Oh, you're muted, Jeff.
Sorry, I was muting myself while I was changing my headset. You know, we don't have any real Jew roars in here, so I had to dress like our favorite Jew roar, Joe here. I had to put on my Joe gear. Get a American flag, or I guess it'd be appropriate if you get like a Korean flag in the background. It would be appropriate. But no, I like the idea. I like the idea. It was I was saying a little bit earlier. Let all the evidence. That's what the jury is there to sort through the evidence and decide how much weight to give the evidence, unless it's clearly illegally gained evidence. I like the idea of letting all the evidence in and letting the jury decide what to do with it. I don't like this because this whole, and we saw so much of it recently in the Depp case and other cases where if only you would have seen some of this evidence that wasn't permitted, maybe it would have been a different outcome. Let it in and let the jury decide, given the proper instructions, and let them decide whether to accept or reject the evidence based on its credibility, the weight to give it, etc. I like this. I like this, Judge, a lot. And I agree with that principle. Like, generally try to presume stuff be let in. Presume it should go in front of the jury unless there's strong evidence to exclude that. If it's got by an illegal search and seizure or something like that, don't let it in. Fruit of the poisonous tree, if it's extraordinarily prejudicial, I mean, if it's completely irrelevant, sure, right? But otherwise, if it's okay, I've got these random nudes that we got from an iCloud hack, like let the random nudes in, definitely. Yeah, let him in. Okay, you got him. I want to get this super chat real quick. Yeah. This is very thoughtful. It says, hey, Mindset and Vice. It's a little off topic, but I lost my grandmother today. And you guys have made the grieving is there. Toast to a life well lived. Prost. I wasn't planning on drinking because it's 4 a.m. But that news. Pull out the Ballantines here. Gonna pour. You're in luck. I am drinking because it is 4 a.m. Yeah. See, Vices and I are on a different program. It's like I haven't gotten there yet. But because of that, we'll definitely say, hey, cheers. Cheers to your grandmother and a life well lived. May we all have lives well lived. Cheers. Cheers. Wait, I'm a juror. L'chaim. A juror. Good stuff. Let's continue with the ballistic motion.
Your Honor, I believe at this time we can move to that. I'm going to turn the presentation of evidence over to Mr. Fernandez, who will call Mr. Grift.
Thank you, Your Honor. May it please the court. State will call Paul Grift.
For the record, spell your last name.
The pink name tag. It just that kills me right there. If he's pink, he's with the state.
My name is Paul Greer, G-R-E-E-R.
Oh, Jesus. Now we know I was wearing a pink name tag.
Oh,
I'm
no.
with the South Carolina Law Enforcement Division, which is commonly known as SLED.
All right, Mr. Greer, for purposes of this council hearing, would you please just describe for the court your educational background and qualifications in the area of firearms identification?
Yes, sir. I received a Bachelor's of Science in Biological Sciences from the University of South Carolina. At the completion of my collegiate career, I began an internship at SLED in the Firearm and Toolmark Department. I was appointed as a firearms examiner, a forensic scientist in the laboratory in 2014, where I began the SLED Firearm and Toolmark course of instruction. This is an extensive training program that's conducted under the supervision of other court-qualified examiners. During that time and extensive period, I conducted many written and practical examinations, conducted many microscopic comparisons, and assisted other examiners prep their cases. At the conclusion of my training, I was then given a comprehensive final exam that included mock casework and was able to begin casework on my own after successfully completing it.
Would you let him handle your weapon devices? Would you let him microscopically examine your firearm?
Ain't nobody talking like him wearing a pink name tag touching my weapon.
Hold on. Yeah, I know you tried to share this here, so let me just add this real quick.
This is from Jessica Unbalanced. She sent this to me.
She already edited it. I doubt it. Oh, that was so quick. Appreciate y'all with the memes. You guys are quick on the trigger finger. Appreciate it.
That's a pretty damn good job, too.
Thank you. And Mr. Greer, would you please describe for us the broad overview is fine for purposes of today.
By the way, he has definitely seen Lindsey Graham's Ladybugs. Like, there ain't no doubt there.
An overview of what firearms identification is and the expertise that you've developed.
Yes, sir. Firearms identification is a discipline of forensic science in which our main objective is to examine fired ammunition components in order to determine if they were fired by a specific firearm.
And are you a member of any organizations, or have you obtained any additional trainings or certifications as it relates to firearms identification?
Yes, sir. I am a member of the Association of Firearm and Toolmark Examiners, which is also known as AFTI. I've been a member of that organization since approximately 2015. AFTI is an international organization that I believe has approximately 1,200 members of folks in the field who do firearms identification and toolmark identification. This also includes technical leaders from the academic world and also from other aspects.
Thank you. And if you would, please describe the process that you go through and the training that you go through in order to become a forensic firearms and tool examiner at SLED.
Sure. That refers back to that course of instruction that I completed, that approximately 3-year or so program, and where I conducted all the microscopic comparisons, looked at things on the microscope, test fired firearms, observed cartridge cases that were fired out of the same firearm, cartridge cases that were fired out of different firearms, bullets as well, learning about firearms, manufacturing process of those firearms, and how that relates to the range of conclusions that we issue as firearms examiners. During that time, I also completed those written and practical tests. Some of those tests include studies that have been conducted throughout the United States and worldwide to include consecutively manufactured bullets and cartridge cases. I've completed those, successfully passed those. At the end of my training, I was given that final exam and also some mock casework in which I was able to complete and successfully pass.
Thank you. And have you had a chance, I know you mentioned you're part of the AFTI organization, AFTE. Have you had an opportunity to attend additional conferences and trainings that they would put on on an annual basis?
Yes, sir, I have. When I'm able or training is available, I attend their annual conference. That is a large conference where materials presented about new technologies in the field or updates, new procedures that may be coming in order to do things or arrive with different items. But I attend those conferences when able. I also participate in other training as necessary, such as our Glock Armor certification when I'm able to do that. AFTI also has other things they provide. Webinars, if I'm able to participate.
Oh, webinars.
I will, take part in.
Oh, we all know we love webinars.
In order to become a firearm and tool examiner with SLED, are you given
and examining my
tool examiner? Tool examiner, really? Wow. Not even gonna say that.
certifications and tests that must be passed, both competency tests and proficiency tests?
Yes, sir. Part of our quality control at SLED, SLED, the laboratory is accredited by ANAB, which is the ANSI National Accreditation Board. That follows the standards set forth by ISO 17025, which is an international accrediting set of standards. And we follow that, and within that, we have a SLED quality control manual that requires before we're able to participate or be authorized to perform work. We are competency tested and deemed competent to do that. Also, in addition, each year we are proficiency tested to make sure that we are maintaining our competency.
Okay. Mr. Greer, specifically relating to the purpose for which you were called today, in describing the area of firearms identification.
Wow, the prosecution in the Dumpster Bros case just rested.
That goes into that.
Really?
Whether that methodology has been subjected to both being, published in journals or subjected to peer review. Would you please talk about that whole process and the culture?
Sure. Firearms identification has been around. During that time, there's been many studies that have proven the reliability of firearms identification. Those studies are published in articles through AFTI, such as the AFTI Journal. Those studies using a scientific method are published in the AFTI Journal, or Journal of Forensic Sciences would be another one that could be included. And those are peer reviewed. Those are looked at by members of the academia or firearms identification, other examiners. Those are reviewed and those are published in those two journals for sure.
Do you know what year AFTI was founded? For how long this organization has been around?
I believe AFTI was founded in 1969.
Of course it was.
69.
Of course it was.
Real quick.
Tool examiner is doing something. Yeah. Geez.
Jessica says, "How dare he call me Jessica Unbalanced? What the fuck? Now we have beef, bro." Yes, bring the drama to Jeff. Jeff loves it. He is definitely.
You got to change your WhatsApp ID if you don't want that.
Flux says, "You and this guy Dick Poontang would grab lunch together. I would grab lunch with Dick Poon any day. Yeah. I would go, because I feel like just hearing him talk in that accent, there's some corrupt Southern shit that's going on. He knows about the bathhouse cases, the people getting the hand jobs from the ballistic expert, right, in the truck stop bathroom. I mean, that stuff's going on.
I'd go out with the I'd go out for lunch with the ballistic expert guy, because he probably knows some fabulous places.
And Hunch said, "Didn't know if you heard the TOS changes YouTube did the past week regarding pew pew content. Real F you to the gun tube community." Yes, the new TOS are messing with a lot of creators. They messed with me originally, and they messed with Joe, a lot of other creators on YouTube. So make sure you're supported. Make sure you're still subscribed. Make sure you ding the bell for all of us, for both Jeff and myself, because a lot of us are getting in trouble because of the new TOS. Let's continue here.
All right. And discussing the methodology of peer review, you indicated that the journals, that the information that's published in journals, that's in fact subject to peer review, meaning other people in the field or folks in the scientific community are able to review it and analyze it. Is that your understanding of it?
Yes, sir. That's my understanding. They would be able to review the article as it's presented prior to publication, and review what has taken place in that article or that experiment, and share their thoughts with that process. Those articles are then, peer reviewed and issued in those journals.
These articles are not only information, but it's also sometimes and frequently an examination of some study that was performed. Is that your understanding of these articles and review of those articles?
That's correct.
In addition to the methodology and peer review publications in your field, could you please discuss the specifics of that peer review process and methodologies in SLED in particular?
Sure. As part of our quality control process at SLED, again, we are accredited by ANAB. We just received our reaccreditation. We're accredited every 4 years during that cycle, and we just received our reaccreditation. And that again follows the ISO 17025 standards. We also, on top of that, have the SLED quality manual, which we follow closely to make sure that we're adhering to those procedures. And as part of that, we have a firearms departmental manual that gives us guidance in how to perform our actual casework, how to perform our examinations with the evidence. In that process, in that quality control peer review, our casework at SLED is
that woman's eyes
verified, and that means that another qualified examiner will look
so
at the
intense,
evidence, arrive at their conclusion.
The Beetlejuice Winona Ryder chick in the back.
Reported,
yeah.
That examiner, we will, if he or she agrees with my results, those will then be reported. The case file itself is also undergoes a technical administrative review process as part of the quality control and peer review procedures.
And as part of your in-house peer review, is that a blind review that is performed?
Yes,
Many companies.
And speaking of the organization, the sort of accreditation organization, ANAB, is that an international organization?
The ANAB stand is in the United States, but they follow the international standards set forth by ISO.
Thank you. And then the second layer would be, so SLED itself, the organization, the law enforcement agency SLED is accredited by ANAB.
The Forensic Services Library.
And then beyond that, SLED Physics has a quality assurance manual, which is followed by your lab. Is that correct?
That's correct.
And then beyond that, the SLED's firearm department has its own manual. Is that correct?
That is also correct.
All right. Has the field of firearms identification been applied in previous similar situations?
Yes, sir.
Okay. Well, let's start with sort of the big picture, the broad picture. How is it typically applied? This field of study.
Firearms identification has been around for years. Since the early 1900s, we have been evolving on firearms identification.
And it's used in court cases across the world. Is that correct?
Yes, sir. That's correct.
Specifically relating to your personal experience, have you been sworn as an expert in firearms identification in previous court cases?
Yes, sir, I have.
And providing live testimony for a trial?
Yes, sir.
And approximately how many cases was that?
I've testified in state and federal courts approximately 25 times.
Certified or firearms identification examiners have been utilized as far as you're aware, per your organizations, have been utilized in court cases across the globe. Is that your understanding?
Yes, sir.
I know you mentioned that this field of study has been around since the early 1900s. Does this applied science use the scientific method when applying, your information you gather and then your opinion that you render?
Yes, sir. It does follow a scientific method and approach in order to conduct our examinations.
All right. Could you please, describe what the scientific method is as applied to this forensic field?
Sure. As far as applying a scientific approach, when we conduct our examinations or we're looking at firearms in the scientific method, one thing when we're working a case or if you're looking at it in this manner, you may ask, you form a hypothesis, are these cartridge cases fired by this firearm? So that would be our hypothesis. We would evaluate the conditions under that, do research, and then we would actually do experiment In this case, this example, what we would do is
I'm sure he's done a lot
fire
of experimenting.
that firearm using similar ammunition that we're comparing it to. We would determine our conclusions and arrive at those conclusions.
We determine our conclusions and
arrive at those conclusions. Yeah. So far, what do you think, Jeff? Just real quick here to check in, guys. Do a little bit of check in. I know we're under 10 minutes until something should start on that side. So is this guy convincing? Like, do you believe he's a great expert, Jeff?
No, he's wishy-washy. Absolutely wishy-washy.
I mean, this is somebody who tries to say the textbook things, but does not come off as convincing. I'm not convinced this guy has handled a firearm in his life, other than in Lindsey Graham's.
He just examines. He examines tools. He's a tool examiner.
Also, the thing is, it's like I imagine somebody might be more of an expert in like machining, or have some more sort of hard engineering. No pun intended, or in this case, maybe it's totally intended. Expertise, but it seems like this guy, to me, he's not convinced me that he even has the expertise to show what he's trying to show. So I know they're walking through the kind of the basics of the expert qualification, which is kind of boring. But man, this is just a layup in terms of dunking on him. And let me show you guys real quick. By the way, please make sure you smash the like button on this. Please make sure you guys are liking this content. Jeff and I, we're up at 5 o'clock in the morning. 5 o'clock in the morning. And what you guys do, you go and repay us by memeing us like this. I mean, come on, guys. come on. It's horrible. You guys are horrible people, but we still love you.
That's Jerry
and
Carroll.
Appreciate y'all. Yes. I think most people have been saying like this guy is full of shit. I don't believe this guy. MG Law right here. This is a good one. He's full of shit if he claims specific guns to the exclusion of other guns. This is the comment I've been getting across all platforms, across locals, Rumble, everywhere else. Is this guy does not know what the fuck he's talking about.
And even if he does, he doesn't sound like it.
He doesn't sound like it. You have to sound like it. The council should ask him if he takes Combivir or Truvada. Are those? I don't even want to ask. I don't even know what they are. I don't even want to ask what type of drugs those are, because this is not medical or financial advice. Not medical or financial advice. And by the way, let me grift a little bit by real quick, guys. Make sure if you're watching this channel that you're also subscribed to Legal Vice's channel, Legal Vice on YouTube. Please subscribe. Please ding the bell for him, because we are doing this as a tag team coverage throughout this trial. And that's something we're going to be doing like kind of day in, day out for the entire Murdaugh trial, for other trials as well. What we're watching right now with the preliminary motions, we're waiting to go live. We'll be doing this the entire time throughout the trial. So make sure you're dinged with him, because we're going to start with vices. We're going to end with mindset. It stays all legal, whether it's vices or mindset, it's legal. Yep. It's all staying legal. So make sure you guys are subscribed. I'm really enjoying this coverage. I'm already enjoying this case. I think it's going to get good as we get into the actual evidence. IWD just clarified it's AIDS meds. Thank you. I knew, but I didn't want to know. Yeah, so let's continue with this. Let's continue this coverage here. Oh, wait, hold on.
Do it. 5
Wolfram
minutes.
Says, has this expert used Amica cream? I'm sure he spread a lot of other creams all over his body. And by the way, guys, I have pulled up the opening statements stream. So whenever that goes live, we're going to switch right over to it. So don't worry, we're not going to miss a thing, guys. So those that were worried about that, do not worry.
So
let's go back to the tool cream guy.
See the case. I look at all the evidence, look at the characteristics on that, examine the firearm, test fire that firearm. I've already compared those cartridge cases to each other and determined that the characteristics of that firearm can be compared to those cartridge cases. Compare that, determine a conclusion. In order to determine, and then our peer review process kicks in. In order to determine whether that is reproducible, or the repeatability of that scientific procedure, that's where our peer review process would come in. Another qualified examiner would come in and look at that. And if he arrives at the same conclusion, then that method has been deemed repeatable and reliable. Thank
In the 25 times that you've testified in both state and federal court, has your
25
testimony,
times.
meaning you could render your opinion to the jury?
Yes, sir, it has.
And were any limitations placed on your testimony in the 25 times you've appeared?
There were none.
All right. The field of this forensic field of firearms identification. Could you please describe the quality control? I know you have mentioned some, but could you please describe the quality control procedures that are in place governing this body of work?
At SLED, again, we are accredited under the ANAB policy, which guides us under those standards in our quality control manual. I'm sorry, could you repeat the question?
What quality control procedures are in place, both in this field of study in general, but also as it relates specifically to how SLED operates? I think you meant, first of all, what's the international accreditation that SLED is, the forensic lab is a part of?
Yes, sir. That is the ISO 17025. So accredited laboratories around the United States, if they are accredited by ANAB, they are all working with those same standards that we are at SLED. They're all adhering to those quality control procedures. Additionally, those who are accredited under the ISO 17025 internationally are also accredited by those same standards and follow those same quality control procedures.
And in order to obtain that accreditation and more importantly, maintain that accreditation, how much, what's the inspection process, both, internal and external? Describe
Yes,
this.
sir. For the ANAB accreditation, we have an on-site visit every 4 years where auditors come and examine our casework, examine our facilities in order to make sure that we are complying with the requirements set forth by their governing body. They review everything that we offer as far as casework, make sure that we're complying with our own policies and as well as theirs. As far as internally, we also complete internal audits each year where other departments will audit and make sure that there's compliance within each department.
And although redundant, please describe to us the SLED quality control manual that's followed in the laboratory.
Yes, sir.
Can you describe it? What essentially is it, and how do you follow it?
Yes, sir. The SLED
nothing more exciting than hearing people explain
follows
manuals.
those, standards that are given by ANAB. It follows that so that way the SLED laboratory has strict guidelines in which we follow in order to make sure that we stay in line with our accreditation procedures and policies.
And if you would, again, although I know you explained it previously, but please describe the firearms department manual that's followed.
Yes, sir. The firearms manual is a set of procedures that we follow as examiners in order to give us instruction and information on how to complete our examinations, how to handle firearms related evidence and tool mart related evidence. It also includes
how to handle tools. He learned how to handle tools. This is rough. Let me get a couple. I know a couple of you guys sent messages on this, and these are kind of like endemic to the C3 Metal over here on local. Says, I have so many complaints about this witness coming from an engineering, machining background, metallurgy, chemistry, and mentioning the scientific method. I mean, his lack of that education. I come from a machinist background. That's something that a lot of you guys have been saying, that this guy does not have the background, the actual background to talk about what he's talking about. I had one comment from, and then of course his background, and then combine that with the lisp, which is what Jackals of Terror Argentum sent a $10 Rumble rant saying, lisp, no chin, back posture suggests adult diapers from a lifetime of backdoor activities. Yeah. So it's not, this guy is not coming off as a credible witness. Luckily, he's not in front of the jury. If this guy gets in front of the jury, there's going to be some laughing. That's all I'm going to say. Derna says, a gun expert in South Carolina sounds like my mama came from the Western Cherokee Res up in North Carolina. When I was 3, I was too small for guns, so they gave me a bow. When I was 4, they gave me a 22.
Wait, I resemble that remark.
I have been to the Cherokee Casino in Western North Carolina. I have been there. I also went to the Bear Pit, which is very sad, actually. It's like a roadside attraction out there. That is
this guy hangs out at the Bear Pit.
That is the saddest place ever. This guy is sucking off the Bear Pit. if you know what I mean. Let's continue.
Terminology that we use within our case files. It gives us guidance to make sure that we are all operating consistently and within those guidelines of the quality control procedures.
And if you would also please describe the code of ethics that is applied to yourself and your colleagues within the laboratory.
No,
Yes, sir.
it's not.
Each employee at the SLED laboratory, including myself, signs a code of ethics that we must abide by each year. And that is a code of ethics for the workplace in our forensic laboratory, and that is recorded within our quality control procedures.
An additional quality control procedure would be the micro-verification process. Please briefly describe that for us again.
Yes, sir. Before a conclusion is rendered via report, each examiner will examine the evidence, arrive at a conclusion, write those conclusions down. At that point, another court-qualified examiner will examine the evidence and arrive separately at their conclusions to create a blind verification. If those conclusions are the same, then the reviewing examiner will sign off on those conclusions so that a report can be drafted. It's also part of that process. The entire case file and report are reviewed for a technical review and administrative review before the report is released.
In order to become a forensic examiner with SLED, is that person required to pass a competency test?
Yes, sir. That's correct.
And you in fact passed that competency test?
Yes, sir.
And are there also proficiency tests that are required each year?
Yes, sir. We do take a proficiency test within our discipline each year.
All right. Please, we're going to talk a little bit about, but I'd like you to describe how the area of firearms identification is consistent with recognized scientific laws and scientific procedures. So I think you mentioned before, but is firearms identification, do you all operate under the general rubric of the scientific method?
Yes, sir.
And again, describe the scientific method and how it relates, maybe how it applies to the firearms identification, beginning with essentially a hypothesis or a hypothesis, and then proceeding along to where it becomes a theory. Could you please describe that process?
Yes, sir. You would look at your evidence, or in this case, if you're just doing an experiment, and try and determine a hypothesis. Are these cartridge cases fired by this gun, or are these bullets fired by this gun? You would do the research to determine what materials you may need. In this case, you may use like ammunition that you're trying to compare to. You would examine those
use the same load
to make sure that the comparison should be completed. At that point, you would begin your experiment. In this case, you would test fire the firearm. You would compare those cartridge cases from the firearm with each other, and also with those cartridge cases or bullets that are questioned.
Don't ever say that again.
Arrive at conclusions. At that point, you would conclude your experiment, issue your conclusions, and open up for any discussion. That is similar to casework in the fact that's a very similar method as what we use there. For repeatability and reproducibility of that,
he knows nothing about reproduction.
Be passed off to others in the field of firearms identification or in academia to review and comment. They could use the evidence or the cartridge cases and conduct their own experiment with it and see if they arrive at those same conclusions. If they do, then that theory has been proven and considered reproducible and reliable.
And generally speaking, in the applied sciences, is it important that the test be as accurate as possible? The test you're trying to reproduce in the lab.
Yes, sir.
Is it important that it's reliable, meaning you can rely on the procedures that you're implementing and the results you're trying to obtain?
Yes, sir.
And is it important that it's repeatable, meaning you could repeat that same process, or your peer review colleague could repeat the same process? That's an important component of this examination.
Yes, sir. That would be an important component of the scientific process.
Oh, we repeat it every single night. Absolutely cringe, guys. I'm gonna go ahead and get this queued up because that obviously is some preliminary motion stuff, which is very interesting, and I'm gonna keep that timestamp in case we need to go back to it and review it. But for now, I know a lot of you are getting antsy in the pantsy. We have clock and seal, right? So guys, we have clock and seal. It should be a matter of, minutes before we go live here with opening statements. So just want to say we're ready. We've got chandelier
now.
We got chandelier. Holy shit.
See, we were debating whether that seal is an owl or whether it's tits. So we just decided to call it Hooters.
Let's go, it's
cover
tits.
both of our bases. It's Hooters. It's both bases.
It's
owls
Hooters,
and
yeah.
tits. Yeah.
The Kakalaki Hoot, as we call it. The Kakalaki Hoot, brought to you by Dick Poon, right? I mean, I think we got it all there. Let me cover some of these super chats here real quick. And guys, by the way, I'm going to try to cover any chats. I know they're going to come in on Rumble, Locals, wherever, during any breaks, natural pauses. If I don't, I will get everything at the end. I promise you, I will not go to bed until I cover every single one. Challenge: competent and proficient in extra special interfamily relations. Oh, God. Derna says he's supposed to be a machine precision expert, and he thought the effed up dimple on one side of his tie was acceptable. Unacceptable. Unacceptable for a Southern gentleman. You need to make sure that your tie is adequately dimpled. Adequately dimpled. Or just don't wear a tie. That's the chat move, guys. Come on.
As a gay man,
who wears a
should
tie
have no
anymore?
pride in his dress.
I mean, come on. It's not fabulous enough, guys. And let me get my grift on, because I've got a grift I got to get out here, guys, because we are on Rumble, and I have a new channel sponsor as of today, which is Field of Greens. If you guys want to try to get a little bit more healthy, if you guys want to try to get a little bit more, in shape, maybe you're, on that, on the fat mindset. Maybe you were trying to work out. Maybe you're trying to be more healthy this year in the New Year's. Make sure you check out Field of Greens. Promo code Mindset. Link is in my description. They're nice enough to sponsor my channel. Very few people are willing to do that, because what we're doing is highly questionable. So go over there, make sure you follow them. They're actually a product that I was using, and the only reason why I agreed with it was because actually I was using it when I was in America, when I was trying to lose weight, be a lot healthier. I was eating vegetables, and that's obviously the best, but they recommend 5 servings of vegetables. And even here in Korea, where we eat vegetables like very often, we have the side dishes, the panchan, where we're getting a little bit of the vegetables in. We don't get 5 servings. So you throw in some Field of Greens on top of eating whatever you're eating right now with vegetables. Maybe you kick it up a little bit and you get there. It's real fruits and vegetables, real stuff in all their products. They don't use any sort of concentrate or other crap. They use actual products, which is why it's a little bit more expensive. But good thing you got that 15% off with promo code Mindset. Like I said, I've used this product. I would only shill it if I've used it, and they're willing to support my content. So guys, go out there and support them. There's very few people willing to do that. So head over there, fieldofgreens.com, promo code Mindset. That's my
record. I'm fat. Support my channel too.
Yes, and support Legal Vices. Make sure you guys are subscribed to Legal Vices and dinged on there. Jeff, do you have a locals as well?
I just have it to handle other people's locals, because locals does not play with Korean banks at the moment.
Oh, that's true. That's true. You do have to make sure you play nicely with Korean banks. They're very, very, very finicky.
Need to keep my tax base here.
Yeah, we've got clock. We've got clock here, guys. So we're still tuned into the clock. Jeff, is there anything you're looking for in the opening statement? So let's just give a little bit of opening statement kind of fluff here. Like, what are you going to look for to hear to convince you that this man murdered 2 people?
I need to hear something from the prosecution that's going to tell us they have direct evidence that he committed these murders. His financial woes, circumstantial. The fact that his wife may have been contemplating divorce, circumstantial. The fact that his sons may be getting ready to flip on him, circumstantial. The fact there's 2 bodies on his property, circumstantial. He said he was, at the time the murders were committed, he was visiting his mother. I'm assuming he has proof of that to bolster his defense, even though the defense has to prove nothing technically. The burden is all on the state. But they have submitted a notice of alibi, and there's alibis he was visiting his mother at the time. And in fact, in the 20-minute drive to his mother's, he made 5 phone calls, and he made about, I think, 2 or 3 on the way back. He's covering tracks. So I think they have a big burden to prove he actually committed the murders, rather than, say, paid someone to do it while he happened to be gone for an hour.
See, that's the thing. I think that's what's going to make this case very interesting. I think the financial crimes cases are going to be boring. They're going to be hella boring because he did it. It's pretty much clear.
Yeah.
Did you send the money? Did you receive the money? Was it fraudulent? Sure. And I frankly, based on what they've got, they probably can convict him on all of those fraud charges, on the, wire fraud, whatever else they got him on in terms of his financial crimes. I think that those financial crimes, the 90 some charges, 100 some charges, all of those not looking good for him. Those are completely different in their elements than proving murder.
Mm-hmm.
And that's the problem. That's the problem right now with this case. And I think that's the big hole, the big gap that we're going to see for the prosecution. And they've got to tell us, hey, we've got video, we've got testimony, we've got people who had their eyes on them, we've got people who saw the weapons, and we're going to need more than circumstantial evidence in order to close this. And somebody asked, does a lot of circumstantial evidence add up? And by the way, we got a little motion here, probably with the clerk setting up in the background. But does a lot of circumstantial evidence add up to a conviction? Well, it can, right? I mean, a jury could. Yeah. A jury can do whatever the fuck they want to do. They can say that based on this circumstantial evidence, we believe he did it. But are they likely to do that? Probably not.
Does that exclude all other reasonable doubts? Is there so much circumstantial evidence that it excludes all other reasonable doubts? If there's even a single reasonable doubt, you have to acquit the guy.
Yeah. I mean, if there's one doubt, right? If you think this guy hired a killer, right? Because I mean, if he has so much money, does this guy look like the type of guy that is going to do it himself? I think this guy would just pay somebody to do it, frankly.
Well, he paid his cousin to try to shoot him in the back of the head while he was changing tires, so his son gets a $10 million payout. So we know he at least has experience in hiring people to try to delete other people.
Yeah, exactly. You guys are already killing me here. I mean, if he was going to hire somebody, guys, he would definitely not hire this guy. He would definitely not hire this guy. That's the last guy you want to hire to try to kill somebody. If you saw how that guy held a gun, you do not want to hire that guy.
Yeah.
So what defense route would I go with? I would go with the route of, like Jeff said, circumstantial evidence, can't prove it, can't place me there, and also the fact that they were killed in a different manner, right?
Yep.
That the son and the wife were killed in a different manner, and if it was him, if it was a single person, then they would likely be killed in the same manner. If one was killed with a certain type of gun, the other one would probably be killed with a certain type of gun. There's no reason why you think he'd run out of ammo or whatever else with one person and then go to the other. So it seems like he might be able to get off based on all those facts. Now, the prosecution has said, we have never before seen footage. We have, footage from the property, which is going to prove this, which is more than anything we've shown before. And we haven't seen it yet. In most cases, we've seen the video in the Sarah Boone suitcase trial. I think we've seen the most damning video. I think it's been released. I think everything else that comes at trial will be the witness testimony. That's my thought. Just based on Florida's public records law, things that have been released out to the public. I think here in this case in South Carolina, we may get different facts. So we'll go back since we're waiting here. We'll go back to the motion testimony for a bit, just so we can chill with something that's a little bit more active. And Mr. Pink Tag guy, who's going to totally tell us how he knows how to inspect your tool.
In addition to all the scientific method and the processes you just described, again, this field of study, this applied science, is it also published in journals and academia for peer review?
Oh, well, if it's in journals, then.
And are you familiar with some of the literature out there, having reviewed it yourself?
Yes, sir.
The journals of tool experts. It's like Out magazine.
Of course, indulgence.
Uh-oh. Looks like Sheriff's
that face.
She's nodding off again.
Again? Wait, has she fallen asleep already?
Yeah, she was asleep through the earlier parts of the motion hearing. Yeah.
All right, Mr. Greer, thank you for answering my questions.
Oh, good question here. Brandon says, how many of these counts, including the deletions, do you think he can lawyer and nepotize his way out of? I think Dick Poon can get him out of at least at least 50% of the charges on the financial side. I don't know.
Okay, so he only gets him out of 50 of the charges. The other 50 are going to stick.
Yeah, I mean, come on. I mean, there's a lot, right? I mean, when you hit somebody with that many charges, you want him to serve some time. I don't think he's going to get out 100% on nepotism. I just don't think that's going to ride him all the way through. I think they got to stick this guy with something. That's my thought. But I don't know if you have another thought there, Jeff.
I don't know much about. I mean, the financial crimes seem to be pretty bad. I mean, he's admitted to some of them already. I mean, he's got $8.5 million that he probably shouldn't have in possession of. He's got a lot of things. He's got his drug habit. He's going to go down for a lot of things. How many things, I don't know. But this murder trial, I'm really keeping an open mind about this.
Yeah, and I'm keeping a complete open mind. They have to convince me of murder. The financial crimes I'm willing to buy. The murder, they have to convince me. The burden is on the prosecution, which, by the way, it is for these jurors. When they walk in there, it's the first time they're hearing about it. They're not like people that have been obsessing over this case for the last 6 months. They're people that are hearing about it. Maybe they've heard about it in the distance, but generally for the first time, specifically with the details.
I mean, it's interesting.
Go ahead, Jeff.
It's interesting that they've charged him specifically with committing the murders himself. So they're convinced, the prosecution is convinced that he hasn't hired someone to do it. So there's got to be some sort of explanation as to why he couldn't do it. Why he could have done it and why it couldn't have been hired out to other people, despite having the alibi of not being there.
Yeah. Very interesting. Why is he doing it himself? If he hired somebody to do the roadside, shoot him in the head thing, right? Because that's alleged that he did that as well, that he hired somebody to shoot him on the side of the road for insurance fraud. Well, why wouldn't he just hire a killer again? If he gets a discount, right? I mean, the second time it's buy one, get one, right? 1+1, as we say in Korea.
Ask you about, specifically relating to some of the criticisms that was referenced in counsel's motion, specifically 2 National Academy of Sciences reports and the what's been referred to as the PCAST report. Are you familiar with those 3 areas?
Yes, sir.
Okay, great. I'd like to ask you, let's just go in chronological order if that works for you. Beginning with the first National Academy of Sciences report in 2008. I believe it was, tell me are you familiar with that study?
Yes, sir, I am.
Okay. Do you recall generally what the study related to, the title or the area field that they explored?
The 2008 article from the NAS was an article by a group of researchers dealing with ballistic imaging.
Okay. If you would, and you have familiarized yourself with that report, is that correct?
I am familiar with it.
What are some of the
This guy is really close to his shoulder.
point, before we go into the reports, having established the foundation for his expertise, we do request that Mr. Greer be admitted as an expert for purposes of the rest.
It's like, don't forget to admit him as an expert
in the field of firearms.
Yeah.
Before the defense proceeds, if you have some questions for him. You have voir dire for this witness?
Not on his qualifications, Your Honor. For purposes of this hearing, he is certified, I believe, under AFTE. I don't have any questions on his qualifications.
All right, he's so qualified.
Shifting back then.
So he's
Mr.
qualified
Greer,
as an
to
expert.
First NAS, National Academy of Sciences report. The test was conducted on ballistic.
By the way, I don't see why they have to do. I don't really see why they have to do this outside the presence of the jury, right? Like, why do they have to? If they've admitted him as an expert, right? So why? I'm struggling to realize why they have to carry this part of the qualification out, especially if we're gonna have to sit through this shit again. If he's gonna come up there and testify, why they would do this in limine? That to me is just slipping me.
They want to disqualify him as an expert, which they failed. Now they want to disqualify the evidence that he's going to be presenting in trial. So now they're saying the evidence shouldn't be admitted.
So right, so they're fighting it not on his expert qualifications, but on the specific evidence. Okay, got it. So that
And now it was kind of both. They were like him and his evidence. Him is in, now they got to go after his evidence.
right. So he's in now. So now they got to attack the evidence. Yeah, I still think they could. I still think they could do this at trial. But that's my 2.5 cents, because we're gonna have to listen to it again.
Yeah.
Imaging technology, and was it critical towards that field? The general gist of it?
Yes, sir. Your Honor, may I refer to my notes?
Take about a 2-minute break.
And once again, I'm not. I understand why they want to disqualify him. I understand that they want to disqualify him. I'm just wondering why they have to do this in limine rather than during the course of the proceedings. That's my question here. Do you guys think he looks guilty? Does Alex Murdaugh look guilty? Poll. I'm gonna do a quick poll and I'll check you guys. Does he look guilty? I know some people have commented on this. Like,
It's like Herman Munster's pasty brother.
he just looks weird. He looks like an odd guy.
A Star Trek villain.
Yeah. I will say I would judge.
Yeah.
I would
You're
judge
gonna
him for
judge
the
what?
undershirt, except for I'm rocking an undershirt right now because it's cold as hell. So
He looks nervous as fuck, I'll tell you that.
for sure. Yeah, he's looking strange as hell. And you've got literally the football team of defense. This is literally the defense table, correct?
Yeah.
Like this whole table of defense, and this is the prosecution over here.
Oh, it's the other way around. The guy in the like 2/3 to the right with the blue shirt, that's the end of the defense table. The lone guy standing there is the prosecution. The prosecution of the last two seats on our right as we're looking at the screen.
Okay, got it.
Yeah.
Wow. That's crazy. That's insane amount of defense attorneys. They should have been like, yeah, all right, this is a pick 2. You guys got to pick 2 and go at this. All right, so I'm going to fast forward here for this 2-minute break and get them back in when they start drilling
to
this
be
expert.
peer-reviewed in those journals.
And speaking of 2-minute breaks, I'll be right back.
Comparing
No
known items to each other and known non-matches, looking at the difference in those. And I feel that this article, if it didn't take into that account of that human interaction, looking at that, the ballistic imaging technology may not have accounted for that.
And just
September 14th admission.
in how many do you know, or roughly how many exams or examinations or analyses have you performed in the field of firearms identification?
At this point in my career, I would say thousands of comparisons.
Oh, he's compared lots of firearms.
All right, and concerning still on the 2008 report, was there some? Did the issues of the report have to amend or issue corrections on the report in certain instances?
The 2008 report was not intended to cause any issues with the admissibility of the firearm and tool mark evidence in its admissibility. There was a statement from the Dr. John Rolfe, who was a member of the study, who had to address some of that information, and that the NAS report did not mean to cause that situation to occur.
All right, thank you, Mr. Greer. Shifting focus to the second NAS, we're calling it the NAS report that was performed in 2009. Are you familiar with that report?
Yes, sir, I am.
And have you had an opportunity to review it prior to today?
I am familiar with the report.
All right, describe to us, if you would, what the nature or the substance of that report was focused on, the area that it was focused on.
The report was generated, and it made 13 recommendations regarding forensic science. 6 of those recommendations related directly towards Fireman Toolmark or AFTI, and those are the recommendations that I'm more familiar with.
Okay. So, and just to be clear, while the report issued 13 total recommendations, 6 would apply to your applied science field of firearms identification.
Yes, sir. 6 of those directly relate to that.
Thank you. All right, if you would, let's walk through, of those 6, let's walk through what the recommendation was, and then I'd like you to address your analysis of that and what your agency does, as a response to that. So beginning with the first recommendation, was there a recommendation to establish standard terminology?
Yes, sir, there was.
Okay, and in general, that's what the NAS report kind of touched on. What is
getting into the evidence?
How does
the actual
SLED
evidence.
operate with all the certifications we've understood? How does SLED operate as far as terminology?
Yes, sir. At SLED, we as firearms examiners utilize the AFTI glossary, which is a book of terms related to
Welcome
firearms
back,
toolmark
ladies and gentlemen.
identification.
Uh,
That glossary.
What I will say now is intended to serve as an introduction to this trial. These remarks are not a charge on the law. I will instruct you on the law in greater
We're live,
detail
guys.
at
We're live.
the end of the trial before you retire
Opening statements. This
to
is it.
consider your verdict. But this is an explanation of the procedure that we will follow in this trial so that you may better understand what's happening. The
Down here.
defendant is charged with 2 counts of murder and 2 counts of possession
Get your popcorn.
of a weapon during the commission of a violent crime, the elements of which will be explained to you later. He has pled not guilty to these charges. He's presumed to be not guilty of these charges. He cannot be found guilty unless the state presents evidence which convinces you, the jury, of his guilt beyond a reasonable doubt. The charge is simply the documents by which the case comes into court. Your purpose as jurors will be to decide the facts of this case. And out of all the people who were summoned to come here for jury duty, out of all the people who live here in Colleton
Keep us on
County,
the left.
out of all the people who live here in the state of South Carolina or any place else, only the 12 of you who will deliberate can decide the facts of this case. And you'll determine the facts of this case from the testimony which will come from this witness stand, together with any exhibits which is made a part of the record or any stipulations entered into by counsel. It is especially important that you perform your duty diligently and conscientiously and in conformity with the oath that you took, because ordinarily there is no way to correct an erroneous determination of facts by a jury. Now, just as only you can determine the facts of this case, as the presiding judge, I am the judge of the law. You must accept as correct the law.
Oh, sweet, we're underway.
To you, then deliberate and decide. I cannot tell you what the facts are. You cannot disagree with me as to what the law is. And even if you disagree, you must follow the law as
You
I
cannot
stated
disagree with me.
to you.
You cannot use jury nullification, so don't
Take
even
the
think about
facts
it.
as you find them to be, the laws I give it to you, you deliberate and you decide the case. Until I tell you that it's time to do so, you cannot discuss the case with anyone, including your fellow jurors. You cannot discuss the case with family, friends, or anyone else. The attorneys in the case, you cannot discuss it with them or any parties or anyone else that might be connected with the case. Should you discover that a fellow juror is violating that oath and that order, you are to bring that to my attention. It's vital that you do not seek information outside of the courtroom during the case. That means that you're not to search internet websites, watch
No Pornhub.
television reports, news reports,
Say YouTube.
any
Say
other
YouTube.
form of social media accounts of the case, because
Come
you are
on.
sworn to decide this case based on the facts as you determine them to be, based on evidence presented in the case, as well as the law as I give it to you. Now, later in the process, I will appoint one of you to serve as the foreperson of the jury. And
They can't
that
be
person will have
foreskins
the
because they're
responsibility
jurors.
of serving
Oh,
as the
no.
spokesperson for the
Sorry.
jury. That person will have the responsibility of presiding over the jury deliberations. And that person will have the responsibility of completing the verdict form representing the unanimous verdict of the jury. In just a moment, the Attorney General will make an opening statement in which he will explain the issues as he sees it, or as the Attorney General sees it. Following that, the defense counsel will have that same opportunity. Then we'll begin with the presentation of testimony from witnesses. I look forward to working with you on this case and to keep the case moving as reasonable as we can keep it moving, but we will not rush, but take the time necessary to have this case fully presented
A
to
nice
you.
long case, baby. Strap in.
We'll now proceed to opening statements.
Strap on.
Right state.
Thank you, Your Honor. May it please the court.
All right, here we go,
Damn.
guys. Here
That
we
was
go.
quick. That was a
Cheers
quick
to the
transition.
start of trial season. Cheers to
On
the
the
opening
evening
statements.
of June 7th, 2021, at the defendant's property off Moselle Road in Colleton County. His son, Paul Murdaugh, was standing in a small feed room and some kennels they had on the property. About 8:50 p.m., and the defendant over there, Alec Murdaugh, took a 12-gauge shotgun and shot him in the shoulder, in the chest and the shoulder with buckshot. And the evidence is going to show it was a 1,000,000-to-1 shot. He could have survived that, but after that, another shot went up under his head and did catastrophic damage
Starting strong.
to his brain.
Yeah, see, this is what you're seeing. He was so calm and cool and matter of fact. Then they click the jury, and now he's animated action
Paul
guy.
collapsed
He's on.
right
He's
outside
performing
that
now.
feed room. And just moments later, he picked up a .300 Blackout, which is a type of ammunition, but an AR-style rifle. And the evidence is going to show that the family had multiple weapons throughout the property. Picked up that .300 Blackout rifle and opened fire on his wife, Maggie, just feet away near some sheds that used to be a hangar. Pow, pow. 2 shots, abdomen in the leg, and took her down. And after that, there were additional shots, including 2 shots to the head that, again, did catastrophic damage and killed her instantly.
Oof. You got my attention.
The evidence is going to show that neither Paul nor Maggie had any defensive wounds.
That was weird.
Neither one of them had any defensive wounds, as if they didn't see a threat coming from their attack.
He had me a .300 Blackout shot.
The evidence is also going to show that both Maggie and Paul were shot at extremely close range. The evidence is going to show it's called stippling. It's almost like a tattoo, that when you get shot very close to a weapon, it leaves marks that the forensic
From
pathologist
Rittenhouse.
can see.
Remember
They were
Rittenhouse.
shot at close range, and they did not have defensive wounds.
Murdaugh wants to kill him.
And the evidence is going to show that the defendant, Alec Murdaugh over there, told anyone who would listen that he was never at those kennels. But the evidence is also going to show from these things that every one of us, most of us carry around in our pockets, that he was there. And he was there just minutes before, with Maggie and Paul, just minutes before their cell phones go silent forever and ever.
We're talking about cell phone data then.
Despite what he told people.
No, see, that's what I was thinking. That was where they had to go. He killed them before he went to his mother's. Like, blam, blam, okay, gets in the car and goes to
Ladies and
mom.
gentlemen, my name is Creighton Waters. I'm with the Attorney General's office, and I'll be the lead prosecutor. I introduced myself before. With me is David Fernandez, Savannah Gow, John Metters.
This is good.
Don Zelinka, John Conrad, and Johnny James. A lot of lawyers. This is a big case. It's a very complicated case, and that's why there's so many people working.
This is very, very good.
Sitting back in the row, we have David Owen, who's the lead investigator. We have Lieutenant Charles Gent, who's one of the agents, Special Agent Ryan Kelly, and Special Agent Peter Rudolphy. Some of the agents that are working on the case, as well as Investigator Isaac Toledo, who's working on the case as well. There's some of the witnesses that you'll hear from as we go through this case. The judge talked to you a little bit about him being the judge of the law, and he gives you the law. And I'm going to talk a little bit about some of the legal concepts before I turn back to those facts. Just remember, though, he's the judge of the law, so you take what he says, but I'm going to explain to you some of the legal issues from my perspective before we talk a little bit more about the evidence in the case. And the first thing is right before you went to lunch, y'all all took an oath. Everybody in this courtroom who's got involvement in this case takes an oath. You know, attorneys take an oath to become an attorney, take another oath to become a prosecutor, judge takes another oath to become a judge, witnesses take oath on the stand, law enforcement take oaths to become law enforcement, but y'all took an oath as well. And the reason why is that y'all have the most important job in this courtroom. Every one of you raised your hand and said that you would well and truly try this case. And it's the most important job here because like the judge said, he's the judge of the law, but y'all are the judge of the facts. Y'all are going to listen to what comes from that witness stand and judge those facts. But you also have to be mindful of that oath. That oath requires you to do that hard job, to make that decision, to call the strike when you see it. It's the same oath. It's just as important as any other oath. This might be the most important in this courtroom. The judge mentioned reasonable doubt, and he's exactly right. It's the state's burden to prove this case beyond a reasonable doubt. That is a cornerstone of our country. I wouldn't have it any other way. It's a burden we welcome. It's what we want. It's a system that has been well tested and true, and we take that burden to prove the case beyond a reasonable doubt. And I want to remind everyone that the emphasis is on reasonable. Okay? It's not any doubt. It is reasonable doubt. Reasonable doubt is often defined, and again, listen to the judge how he defines it, but reasonable doubt is a doubt that would cause a reasonable person to hesitate to act. To hesitate to act. And when you hear
sounds reasonable to me.
Coming from this stand about this particular case, I submit to you, you won't hesitate to act. Again, remember the emphasis is on reasonable and reasonable doubt. The judge mentioned the charges. And there are 4 of them. First indictment accuses Alec Murdaugh, to which he's pled not guilty, but it accuses him of murdering Maggie Murdaugh. The second indictment accuses him of murdering Paul Murdaugh.
Okay.
The third indictment accuses him of possessing a firearm during the commission of a violent crime, that being the murder of Maggie Murdaugh. And the last one accuses him of possessing a firearm during the commission of a violent crime, and that being the murder of Paul Murdaugh.
Okay, so they are certain he did not hire someone to do this.
Well, judge against
that's their theory.
It is the unlawful killing.
No wiggle room.
With malice aforethought.
With malice.
And what is malice? Malice is
good. Explain it. Good.
That's ultimately going to be for y'all to determine as to what was going through Alec Murdaugh's mind when he committed these.
Bullet was going through his
What is
wife's
malice?
mind.
Malice has often been defined as the intentional doing of a wrongful act without just cause or excuse. It is the intent to inflict an injury under circumstances that the law would presume an evil intent.
He's doing well to explain it in simple language.
And when you look at the circumstances of the crime, when you look at what led up to this crime, the evidence is going to show that there was malice aforethought. Aforethought, what does that mean? It means it has to exist at the moment you commit that crime. It doesn't have to be planned. It doesn't have to be planned for any long period of time. It just has to exist a split second before the crime is committed. But when you see this crime and you hear all the circumstances, the evidence is going to show that a forethought existed for a while.
He's doing a very good job of road mapping where he's going to go with the case. He's just got to follow through with it.
Yep.
You're also going to hear about circumstantial evidence. And a lot of times people hear, oh, it's just a circumstantial case. But the law says otherwise. The law says that circumstantial evidence is just as good as direct evidence. And what's the difference between the two? Direct evidence is supposedly about the storm out here, from what I'm told. Direct evidence is if it's sunny outside and a witness goes outside and it's sunny and they come in here and they get on that witness stand and because they saw it raining, they sit on the stand and said, I was just outside and I saw it rain. I saw it raining. That's direct evidence. They actually saw it rain. But to give you an example of what circumstantial evidence is if the witness goes into a room where all the curtains are drawn, and when they go into that room, it's sunny outside and everything's dry. And while they're in that room, they see it darken behind the shades. They hear thunder. They hear the wind blowing. They hear the sound of raindrops on the roof. And then they open up the door, and it's not raining, but everything is wet. There's puddles in the driveway. There's puddles in the street. There's puddles in the yard. There's limbs down all over the ground. And then they come in here and say, yeah, it was raining.
That's actually a logical fallacy. There could be other reasons why it's wet outside. Sprinklers, spilled water bottles.
Now, I guess it's possible that somebody could have been standing outside their window and beating the drum to sound like thunder and blowing a fan to make it seem like it was the wind and somehow got enough water to coat the entire neighborhood. But that's not a reasonable.
The good. Explain what reasonable is. That's good.
That's not a reasonable.
Good.
Another thing, and this is crucial, what you're going to do in this particular case, is determine credibility or the believability of witnesses. So it'll be your job to look at the evidence, the exhibits in the case, but also the witnesses and decide if it's truthful, if you believe it, if you can rely on it. And the judge is going to instruct you that you can believe one witness against many or many witnesses against one. You can believe all the witnesses' testimony or part of the witnesses' testimony. It's up to you, first individually and then as a product of your deliberations. And what you're required to do there is just to rely on that good old-fashioned common sense. Does it all fit together? Is it corroborated? Does it fit with what you would expect? Does it fit with what you expect how real people would act? Does it seem real? Or does something seem a little off? Does something seem a little off?
You know, the scariest thing is people's common sense. People's common sense.
Yeah.
You're going to see body-worn camera of him at the scene when law enforcement arrives.
All right, that's good evidence.
Hear what he says. Hear what he says about that night. You're going to hear 3 recorded statements on video that he gave with law enforcement, and you're going to hear how things progress about what he says and what he says he did that night. Watch those closely. Watch his expressions.
Watch him in the court.
Listen to what he's not saying. Use that common sense. Does this seem right? Or does something seem a little off?
He didn't say he killed him, so therefore he did.
I mentioned that Maggie was killed with a 300 blackout rifle, an AR-style rifle that chambered in 300 blackout ammunition.
That sounds scarier than 3.62 by 35 millimeter.
Christmas of 2016,
sounds
Alec
scary.
Murdaugh over there bought 2 300 blackout AR-style rifles. And then not long after that, one of them went missing from Paul's truck. And time went by, and in April of 2018, Alec Murdaugh replaced that rifle and bought another one. 3 total blackout rifles that they had. One of them went missing years ago, and a replacement was bought. You're going to hear evidence that Paul and his friend were using that replacement gun. They were standing right outside the side door to the gun room of the house, and they were sighting it in, firing down into a field. and the cases were ejecting. The cases are the empty shell from a bullet, and they were ejecting out into the flower bed right there. And then there's a range across the street, and they shot it there, and there's cases ejected there as well.
Nothing like a good ejaculation, I guess.
Just weeks prior to the murders, prior to June 7th, 2021, when Maggie and Paul were murdered, and you're going to hear forensic evidence that the cases that were found in that flower bed and the cases that were found across the street at that range were ejected out of the same weapon that fired all the cases that were around Maggie's dead body, that killed her.
Release your brass, people. Pick up your cartridges.
Killed Maggie.
Or use a revolver.
And you're going to hear evidence that
Not legal advice.
blackout that Alec Murdaugh purchased when law enforcement arrives at the scene on June 7th, 2021. He can only account for one of them. He can only account for one of them. And that replacement gun is nowhere to be found.
Scout's honor.
You're also going to hear evidence that the type of ammunition, the exact brand, the exact model of ammunition that was used to kill Maggie, S&B, 300 blackout ammunition, and 147 grain bullets, that exact ammunition, boxes, empty boxes of that ammunition, is found all over the property. The very same brand and model of ammunition that was used to kill her.
That's circumstantial as hell.
Yeah.
And you're also going to hear evidence, the same thing about
It's a very popular ammunition for those who aren't shooters. Very popular.
Well, they better be able to show how the weapon that went missing years ago was not the weapon used.
Winchester #2 turkey legs, the 2 rounds in the shotgun that killed Paul. Family weapon, same ammunition. It's all the problem. You're also going to hear evidence that about a week after the murder,
Nicholas in the house.
Knives and bleach.
Mr. Alec
Great new
Murdaugh's
channel, by the
father had
way.
died, Mr. Randolph. And about a week after the murders, he shows up early in the morning at his parents' home, where his mother still is in late-stage Alzheimer's.
Okay, that's why we
Alameda
did
in
it.
Hampton. It's uncharacteristic for him to show up early, uncharacteristic for him to show up at all like that. And he comes in, and he's carrying something in a blue tarp, and he takes it upstairs. And eventually law enforcement finds out about that. And they go upstairs, and they find a wadded up, very, very large raincoat in a blue color. Could look like a tarp. And you're going to hear evidence that it was coated with gunshot residue on the inside.
The inside.
You're going to hear other evidence of gunshot residue.
Well, that's not very good.
Hear that there was gunshot residue on Alec at the scene. You're going to hear the evidence that there was gunshot residue on the seatbelt of the car.
On Alex?
You're going to hear evidence that when
That's not
law
conclusive
enforcement
either.
got to the scene, he had gone and gotten a shotgun, Paul's shotgun, and that Maggie's DNA was on that shotgun.
When someone
You're gonna hear
comes
other
to
evidence from
your house
DNA,
and you'll get the shotgun.
gunshot residue, firearms examiners. There's going to be a lot of forensic evidence in this case. And I'm not going to get into every single bit of it right now, but I will say that a key piece of forensic evidence that you're going to hear in this case is the cell phone note. Alec's cell phone, Maggie's cell phone, Paul's cell phone. You know, this is all amazing technology that most of us carry around in our pockets. It really allows
Scary
us to do a lot of
technology.
things and get a lot done. But this cell phone keeps track of who we're talking to, who we're calling, who we're texting, whenever we access apps. And every time you do that, there's a record kept in this phone unless it's deleted somehow. And if you're using certain apps, you can even get GPS information where you were when you did that that's stored on these phones. You're going to hear evidence about that. You're going to hear evidence that when you make a call and it pings off a cell tower, some location information can be gathered from that as well. And so it allows an investigation to take this and piece together what someone was doing on a particular day, and not only what they were doing, but who they were interacting with and how they were interacting with This is going to be crucial evidence for you to consider. You're going to hear that particularly Alec and Paul, but also Maggie, were prolific cell phone users, to the point where Paul's friends even had a nickname for him about his cell phone usage. Before I talk more about that, there's 3 family properties I need to talk about. Okay.
Massive
First one
properties.
I
These are
mentioned is
huge
Moselle.
properties.
Moselle in Colleton County. It's called Moselle. It's off Moselle Road, but everybody refers to it as Moselle. And that property is it's a lot of acres. There's a main house on it, and there's a driveway that goes to that main house. But it used to be an airstrip, and there's an airstrip that goes down, and then down the way.
Jesus, there's an airstrip on the property.
That's how you know illegit stuff is going down.
4-minute walk, 45-second drive is the kennels and the shed that used to be a hangar where Paul and Maggie were murdered.
The camera's muzzle off.
Less than a third of a mile away. You can see the kennels from the main house. You can see the main house from the kennels. The family also had a house in Edisto at the beach. And the evidence is going to show that that is where Maggie preferred to stay, particularly in the summer months. She liked the beach. She was not a hunter. She didn't want to be at Moselle. She didn't want to be at the lodge where it was hot and buggy. She liked being in Edisto. And then you're also, I've already mentioned, the house in Alameda, which is where his parents' home. On June 7th, 2021, you're going to hear evidence that his father went into the hospital and the prognosis was not good. And in fact, he died a few days later. And his mother is in late stage Alzheimer's, and that house being cared for by a caretaker. You're going to hear from that caretaker.
Mr. Waters.
Yes, sir.
Let me pause for a moment. We'll be at ease in just a moment.
Yes, sir, Your Honor.
Oh, we got a little bit of pause here. So what do you think so far, Jeff?
I like the roadmap he's laying out.
Clear language, very colloquial, explaining everything step by step, taking time, starting strong. Like I remember that opening. I mean, when you're talking about the bam bam, using the onomatopoeia, you're kind of spelling that out there. I love the hilarious captions, by the way. They are freaking amazing. I'm not sure, guys. I'm gonna be honest with you. I'm not sure how I feel about this split screen view. I think it's kind of, you like it?
I like it because it shows the defendant's reaction to what's being said. I like that.
Well, according to our poll here, Jeff, 81% of the chat believes he looks guilty, that Murdaugh looks guilty.
Yeah.
And we will do a do you think he's guilty at the end of opening statements. So
that's a very important distinction. Does he look guilty and do you think he's guilty are 2 very different questions.
Yes. And by the way, this attorney that's presenting right now, the opening, is a prosecutor. This is a prosecution opening statement. So you start with the prosecution, you go to the defense. That's the typical order, both in terms of the case and in terms of the opening and closing. There are, during closing, there's rebuttal closing. There's going to be rebuttal from the prosecution. So they get kind of that second lick. But here it's just, 1-and-1 opening and opening. From the prosecution defense. So we're on the prosecution right now. Also, who wears a mask? Who wears a mask? Come on, guys. We're in South Kakalaki. What are we doing here?
Hey, who's wearing a mask?
The guy just ambled right into the court right there. I am actually kind of surprised that this is not a full courtroom. I'm wondering if either people didn't know this was going and show up, or they're limiting folks that are coming in. I mean, it's kind of surprising that this courtroom is not completely packed with people.
Yeah, that's weird.
Yeah.
Do we see James? I didn't notice James there anywhere.
I'm looking for James. You guys see James? I don't see James there. I'm gonna have to hit him up and say what he said he was gonna make it every single day of the case. While we're waiting, some excellent memes from the meme god here. I was gonna show them at the end, but the guys on locals, they make good ones real quick. Kick ass, boy. And then you've got that one. Very good stuff. Appreciate y'all with the memes. Yeah, I'd be angry too if I had to pay for all those lawyers. Oh yeah.
That was a weird break.
You may proceed.
Bathroom break, maybe?
Yeah.
All right, we were talking about the three family properties, Moselle, which has the main house, and the kennels / sheds. The main house has a driveway, but the kennels also have a driveway. And the evidence is going to show that that was actually as commonly used as the main driveway. In fact, the mailbox is by the kennel driveway. Driving right past those kennels for Paul and Maggie. I told you that you're going to hear evidence that Maggie did not like being in Moselle as much as she liked Eddystone, the beach house. But that, on June 7th, 2021, she came back to Moselle. And the evidence is going to show that she arrived about 8:15. And the evidence is going to show that from the cell phone.
It's got some notices up on the cell phone.
At the house, at the main house. Alec Murdaugh himself says that they ate dinner, and the autopsy is going to reflect both Paul and Maggie having similar stomach contents, indicating that they recently shared a meal together.
Now I'm wondering why there's so few people in the courtroom.
It's weird.
15 minutes after they arrive,
It's like, stay away if you know what's good for you.
Paul's phone starts moving towards the kennels. You're going to hear evidence again that the defendant said he was never at those kennels, that he was napping after they ate, and he was at the main house and never went there. You're also going to hear evidence about how much Alec used his own cell phone, and it would be unusual for him to be anywhere without his cell phone.
Well, these days it's unusual for anyone to be anywhere without their cell phones.
Yes, that is weird.
55 seconds. Paul recorded the video. He was down at the kennels because he had been talking to a friend of his. We're going to hear from this friend because his friend's dog was in the kennels and they thought there was something wrong with the tail. And Paul was recording a video of it to send to his friend. 8:44 and 55 seconds. And on that video, and you'll see that video, and you'll hear from witnesses that identify Paul's voice, Maggie's voice, and Alec's voice. Told anyone who would listen he was never there. At 8:44 and 55 seconds, there's a video. The evidence will show that he was there. He was at the murder scene with the two victims. And more than that, just over 3 minutes later, 8:49 and 1 second, Paul's phone locks forever. He never reads another text. He never sends another text. He doesn't answer calls. 3 minutes after that video has the defendant at the murder scene with the two victims, Paul's phone goes silent forever. And in fact, another communication comes into the very friend that he was talking to the dog at 8:49 and 35 seconds, just 35 seconds later. He doesn't answer. He never answers another thing forever now. And on top of that, Maggie's phone locks at 8:49 and 31 seconds, around that same time. And she never answers another text, never sends another text, never makes another phone call, never receives another phone call. 3 minutes, ladies and gentlemen. 3 minutes.
Okay. He said in his alibi, he said he left shortly after 9 p.m. to visit the family. That's a problem.
Credibility, ladies and gentlemen. Credibility. So what happens after that? Well, you'll hear evidence that Alec's phone was conspicuously, he didn't have a lot of activity from about 8:09 p.m. until 9:02 p.m. And if he was at the kennels, which the evidence will show, why is his phone not with him? Why is it not showing activity? But you will hear that at 9:02, all of a sudden his phone does start to pick up activity. At 9:02, he calls, he starts moving. At 9:04, he calls Maggie's phone. Doesn't answer, of course.
Ooh.
Doesn't answer. He calls his father, Randolph, who's in the hospital. Doesn't appear there's an answer there. He calls Maggie again at 9:06. Remember, he's just a third of a mile away. You can see it. At 9:06, she doesn't answer. At 9:06, he turns on his car, his Suburban, and he texts Maggie that he's going, be right back. I'm going to go check on Mom. And he doesn't.
Yeah, that's where they're going. They were dead before he left.
It's a common place to be, even though you can see it. He's called his wife 2 times and texted her, and she hasn't responded. But he didn't just drive down there and say, hey, I'm heading. You guys want to go? What's up? What's up?
What's up?
Right there.
What's up? What's up, man? Don't go too dramatic, guy.
He then drives to Alameda, where his mom is suffering from Alzheimer's, and the caretaker is there. And he starts calling people. He's talking to people. It'll be up to you to decide whether or not he's trying to manufacture an alibi.
Well, it's looking that way now, pretty solidly.
Yeah.
It's there to Alameda. You'll hear evidence about whether or not that was usual. You'll hear evidence about how he was acting when he got there. And he's only there for 20 minutes because he's back underway at 9:44. And he makes more phone calls on the way back. Calling friends, calling people who will answer. It'll be up to you to decide whether he's trying to create an alibi. And he gets back to Moselle at 10:01. He calls 911 at 10:06. Listen to that 911 call. Listen to what he says. Listen to what explanations he may offer. You're going to hear that 911 call, but you're also going to see the body-worn camera of the officers who arrived at the scene. The video camera.
I'm ready for that.
So it records what they're doing.
Yeah.
Now I'm ready for that.
And you're going to see what he did to Maggie and Paul. It's going to be gruesome. There's no other way around it. It's what he did. You're going to see crime scene photographs. You're going to see the traumatic injuries that were suffered. You're going to hear from a pathologist, a doctor who will examine the injuries. It's going to be gruesome. There's no other way around it. On that 911 call and on the body-worn cameras, pay attention to what he says. Look at how he's acting. But he says within a few minutes of each one of those, he says, this is about the boat case. This is about the boat case. And you're going to hear some of what was going on in Alex Murdaugh's life leading up to that day. Stuff that happened that very day, stuff that was leading up, a perfect storm that was gathering, much like the storms that are coming outside today. Listen for that evidence. Listen to that gathering storm that all came to a head on June 7th, 2021, the day the evidence will show he killed Maggie and Paul. This has been a long, exhaustive investigation.
This is a good opening.
It's going to be.
He's got my attention.
Because it's complicated. It's a journey. There's a lot of aspects to this case. There's a lot of factors to this case.
He's got a lot to prove. He's got a lot to back up what he's saying, but if he can.
You start to put them all together, piece them together like a puzzle, all of a sudden the picture emerges and it's really simple. It's really simple. Once we get to the end of that journey, and you have a chance to deliberate, the evidence is going to be such that you're going to reach the inescapable conclusion that Alec murdered Maggie and Paul, that he was the storm, that the storm was coming for them. And the storm arrived on June 7th, 2021, just like the storms that are heading here right now, that they died as a result. Yeah.
That was a little lame.
Thank you.
Wow, that was short and to the point. Okay, I thought it would go on a lot longer than that.
No, that was good. That was good. It was
great.
To the point.
Yeah.
It was strong. He didn't lose me. He had my attention the entire time. He didn't overdo it. He says, we're going to show it. Defense.
Yep. Man, they're just cranking them out too. There's no pauses.
That's because I wish I could call and text my wife. She wouldn't respond. I would roll out to the bar as well.
Jury, my name's Dick
No doubt.
Harpoon.
No doubt.
I think I introduced myself.
Dick
to you
Poon,
all.
baby. Dick
The
Poon.
attorneys, the three other attorneys, Jim Griffin, Philip Barber, Margaret Fox. It is our honor to represent Alec Murdaugh.
Ooh, I don't like how this is starting already. Just the first sentence lost me.
I say it's our honor because I submit to you what you have heard from the Attorney General as facts are not.
Everything that guy just said is just bullshit.
They're his theories, his conjecture. Now stand up. This is Alec Murdaugh. And Alec was the loving father of Paul and the loving husband of Maggie. You're not going to hear a single witness say that their relationship, Maggie and Alex's relationship, were anything other than loving. You're going to hear about how they went to a baseball game the weekend before. You're going to hear about their relationship. You're going to see texts and emails indicating a loving relationship.
I know who he reminds me of. He reminds me of Young Frankenstein. Peter Boyle playing Frankenstein's monster in Young Frankenstein. That's who he reminds me of.
Paul and Alec riding around looking at some trees they planted. It's a Snapchat that Paul sent to other people because the trees were not planted very well. They were cantilevering over. They're laughing. They're having a good time. That would be about an hour before the Attorney General says he swatted them. When I say he swatted them, when they were swatted, and no question, Paul Murdaugh was shot twice with buckshot, 12-gauge buckshot, once in the chest. And by the way, that shot would indicate it was in the chest and came out under his arm, like somebody that might have been holding up their hands. So when he says no defensive wounds, he perhaps was being held at shotgun. I mean, I can make the same sort of speculation that the Attorney General can, because that's all he's doing is speculating. What we do know is 12-gauge, fairly close range shot to the chest. He must have been turned because it comes out under his arm. There's wadding, if you're familiar with a shotgun, under his arm. The second shot ended up, and there's going to be some question about the direction of that shot, but ended up entering his skull cavity, and the gases from that shot literally exploded his head like a watermelon hit with a sledgehammer. All that was left was the front of his face. Everything else was gone. His brain exploded out of his head, hit the ceiling in the shed, and dropped to his feet. Horrendous, horrible, butchering.
This is dangerous ground he's on.
Yeah, he's pushing it here.
To find Alec Murdaugh guilty of murdering his son, you're going to have to accept that within an hour of having a extraordinarily bonding, you can see it in the Snapchat, that he executes him in a brutal fashion.
Snapchat? Okay, we're gonna have I have some questions.
Not believable. Now, Maggie,
If only they'd followed the
shot
self-defense guy's
running.
self-defense techniques.
no defensive wounds because she's shot running, and after she falls to the ground and has one bullet that has hit her and probably traveled up and hit her brain, she's on the ground, and whoever the perpetrator was walked up, took that AR, and put one in the back of her head.
How does he know it's an AR?
Executed. Executed.
This is why I like the split screen.
Why? This is going to be interesting because we don't know why. He doesn't know why. He's got theories of this and theories of that. But why? Number one. Number two, what was it in that hour between when he's yucking it up with Paul? And let me say this to you. His record, he was interviewed. He comes home and finds, there's no question about this. They've got telemetry from his car. He left the house at 9:06, returns at 10:01 after seeing his mother who has dementia. Now remember, that day, his father, who is dying, is taken to the hospital. Mom's home alone with the housekeeper. Perfectly reasonable for him to want to go see her. And later than usual, because his father's not there. He's in the hospital. He dies 2 days later.
Oh, geez.
Dies 2 days later. So the question is, if he leaves at 9:06 and he's back at 10:01, he literally, I mean, and he can account, the cars and the cell phone records account for where he was between 9:06 and 10:01. Now, the cell phone records, and you're going to hear this from their own experts, are incomplete. They're incomplete. And we're submit one of the reasons they're incomplete. And by the way, how do they find Maggie's phone? Maggie's phone was thrown out on the side of the road about a quarter of a mile away from, a little bit more, maybe a half a mile from the Moselle property, thrown out on the side of the road. They found it by using Find My iPhone. And the way they did that, they had to open it or have access. Who gave them the code to open the phone? Now, Murdaugh.
Okay, he could still be an abusive
Not
husband that
destroyed,
demands
thrown
access to all of his wife's stuff.
What you're also going to see is that Alec Murdaugh was calling that phone at 9:06. As he leaves the house, he did call her twice and texted her.
Yeah, he's walking the
And
line,
we
and I
also
don't like
know
it.
that at 9:06, as he cranks his car, as the cell phone records show that, as the telemetry data shows the cell phone linking up with the car, that phone is being thrown on the side of the road almost a half a mile away. Now that is Houdini. That is magic. That is inexplicable. Now, I was making notes while the Attorney General was talking. But let me tell you what is more believable. The night he comes home and finds his wife and son butchered. And when I say butchered, you're going to see these photographs. When I see them now, after having seen them for the last 4 or 5 months, it still shocks me. It still is tough to look at. It still bothers me.
This is not necessarily helping.
No, I don't like this.
His son laying in his own blood with his brain laying at his feet, shot to hell. He walks over, he checks to see if there's any life there, although, I mean, he's seeing his brain laying outside his body. He knows there's nothing there. He goes over and tries to get a pulse out of Maggie. No pulse there. Calls 911. I want you to hear that 911 tape. It is a man hysterical, in grief, trying to figure out what's going on. And he tells the 911 operator that he's concerned, and he drives back up to the house. And by the way, you can't see, I've been out there, you can't see the shed where you might see the top of the shed. There are pine trees between the front porch or the porch on the house and the dog pens. And it's not a third of a mile, maybe by the way the crow flies, but it takes a little bit longer to drive down there. And this is not unusual for them to communicate by cell phone or text, even when they're all on the same property. It's 1,100 acres, big property. They hunted it. So what I'm trying to say to you is that the Attorney General has given you his view. And again, you can't see the shed. And I'm going to ask the judge at some point during this trial to ask you, the jury, to be able to go to the scene so you can see it. You can understand the proportions. You can
Field trip day.
Field trip. That'd be
Because
hilarious.
the facts are what matter here. The facts. Let me give you another fact. You're going to hear their witnesses explain the catastrophic injuries to Paul. His head literally exploded. And whoever shot him with that shotgun was probably no more than 3 feet away. Maybe closer, maybe a little further away. His head exploded. You would be covered
Stop
in
saying
blood
that.
from head to foot.
They're really going into those details.
In blood.
It's like all these horrible things happened, but they had a good time earlier in the day, so it couldn't have happened.
They test. Well, first of all, you're going to see in the videos from the officers that arrived that night. There's no blood on him. They didn't find any blood on him. SLED's testing indicated 12 different places on his shirt and pants. No human blood detected. Period.
Okay.
You'll see pictures. A white T-shirt, no blood on it. Those are facts.
Like an undershirt?
Those aren't theories.
Yeah.
Those are facts.
Shirt.
Another fact that is, I think, the reason we're here today. When you hear those questions on the videotapes on the night, now he's found his wife and son brutally butchered. You can hear on the 911 tape, he is hysterical. He comes in and out. It's consistent. If any of you have ever, you got to use your experience as part of this deliberation process.
Ignore the evidence, focus on your experience and feelings. Good tactic.
Family member. It's numbing. It's the minute you find out, or if you see them dead, it's numbing. You go into shock. So anything he said that night is in the context of just an hour or two before finding his wife and son butchered. He drove back up to the house while he's on 911 saying, I got to get a gun. Whoever did this might be out there. And he gets a gun. What's fascinating about that is he gets a 12 gauge shotgun and he grabs some shells. These people hunt a lot. They have guns everywhere. He grabs some shells. He puts a 16 gauge, a 12 gauge, grabbed a 12 gauge shotgun, put a 12 gauge buckshot in, and then he put a 16 gauge buckshot in. That's how shook up he was. Guy hunted all his life, and he put a shell in that you couldn't fire a 16 gauge from a 12 gauge. Makes no sense. He was traumatized. GSR, their own expert at SLED said the amount of particles of GSR are consistent with him going up and picking that shotgun up. They want to talk about GSR? Again, if you fired a shotgun,
gunshot residue,
and a rifle 6 times, you'd be covered in GSR. Those are the facts. That's not his theory. The facts. Now let's talk a little bit about these ARs. Again, you're going to hear testimony. A lot of guns. They had a gun room. I don't live in Calhoun County. I live in.
There's nothing to convict on that fact.
That's
normal.
In downtown Columbia.
Yeah.
But apparently, if you live on 1,100 acres and you hunt deer, and you hunt whatever they were planting those sunflowers for, again, you have a lot of guns. The truth is, in 2017, and you'll hear the testimony, that Alec bought 2 blackouts, one for Paul and one for...
Don't use blackout. That's their language. It makes it sound scary.
And
yeah,
Paul had his stolen. He bought another one for Paul.
Paul is irresponsible.
Now, Paul was very irresponsible with guns, cars. He'd leave guns around. He'd leave guns in cars. He oftentimes left guns down at the dog pens in the feed room. Now, I can't tell you whether he was shot with his own weapon or not, or his mom was shot with his weapon or not. But I can tell you that they weren't shot by Alex. They don't have the guns. There's no way to tell, exclusively without having the weapons, what weapons those were fired by. And we'll be talking a little bit with the SWAT experts about that. The sort of overarching issue here is why murder on June 7th, 2021, why is it September of 2022 before they charge him?
Irrelevant.
And I will tell you what happened that night. And this is a problem.
Look at Alec Baldwin. It took 15 months to
And the
indict
question
him.
is pretty aggressive. You'll hear it. He's traumatized. They suspect him. They show up. He's got a shotgun. They suspect him. And the next morning, 2 people found butchered, and here in Colleton County, Moselle Road. The police announced, "Don't worry. There's no danger to y'all. There's nobody out there that could pose a danger to you." Because you see, they decided that night he did it.
The rush to judgment argument.
Without cell phones, without any of that. And they've been pounding that square peg in the round hole for the last, since
Pounding
June
the
of
hole.
2021.
Come on, man.
Resulting in charges in September of 22. And so if he felt, and he did, and you'll hear it, the accusatory fashion he's being interviewed in, he may not have dealt all the facts. But by the way, whether he'd been down to the dog pens that night or not, really didn't matter. Really doesn't matter. Because you're going to see cell phone activity that would be, let me put it to you this way. Paul's phone, 850. Maggie's phone, later than that, 854. Clearly, it's still being used. At 9:06, he's up at the house, getting in the car, cranking it up to drive over and see his mom. He says a few hundred yards away. It's a little bit further than that. But the point of the matter is, he would have had to have executed both of them, got back up to the house, got the bloody clothes off. And by the way, they seized his clothes from that night. They'd never searched his house for any other clothes that we know of. Although that night, he gave permission and they got a search warrant. Go to my house. Go look through everything. Where are the bloody clothes? Where are the bloody clothes? And of course, I would tell you that they've woven this story together because they want everything to be consistent. What's important about that is the judge, and by the way, there's no eyewitness. There's no forensics tying him to the murder.
Not necessary.
When I say forensics, fingerprints, blood, whatever, tying him to shooting anybody that night. The cell phone records would indicate he would have had less than 10 minutes to kill him, get up to the house, get in the car and crank it up. He'd be covered in blood. Now, if they think he was beginning to establish an alibi, there's no evidence of that. The evidence is consistent with him seeing them earlier at the dog pen. And by the way, that audio they have of him and Maggie, they're talking about one of the dogs killing a chicken.
Okay.
And they were debating whether it was a guinea hen or a chicken.
Relevance?
No animosity. Very normal discussion. Paul's very happy. We know that Paul, after that, is texting back and forth with a girl about going to the movies. Nobody's down there threatening him. Daddy's not pulling out a shotgun and killing him. For, 10 minutes after that, he's texting this girl. So, big question. One shooter or two? Two guns, shotgun and an AR. And by the way,
I knew they were going to go this route.
It's a wounds because she's running. What's she running from?
Her husband.
And could you shoot? Typically, she had a little shed right
Different
probably
range.
150 feet from the feed room on the other side of a wall. Perhaps she heard the shotgun blast and came around and saw somebody or 2 people, and whoever it was opened up. Was there enough time to kill Paul, and then find the AR and then ambush Maggie. Much more likely there were two people, but again, we don't have to prove anything. Let me sort of share the
He should have led with that.
Yes.
Examine this.
Go hard on the reasonable doubt.
You have agreed to follow the law, and here's the law. Here is the law. He didn't do it.
That's
He
not
is
a law.
Innocent.
Yeah, that's
As
not.
you sit there right now,
That's weak.
sit there right now, when you look at him, you have to believe he is innocent. He didn't do it. Now, let me tell you, that's so difficult to do. I get it. And the way maybe the best way to explain it is this morning or yesterday, nobody really reads newspapers anymore, but if you're reading the newspaper, looking at the internet, and you read the police had arrested somebody for some heinous crime, the natural inclination of everybody, all of y'all, is to say, thank God they caught him or her. Thank God that person is in custody. And you did something that's so natural. We all do it. You presume.
I don't think he should have said that.
Had arrested the person that committed the crime. You presumed him or her guilty. That is the natural thing to do. And you know what? That's fine for you to do. Any other day except today. Because you took an oath to follow the law. And the law is, he is innocent. He's presumed innocent. That is your presumption. Your mental framework is, he didn't do it. They've got to prove it to me beyond a reasonable doubt. Now, what's even more difficult, and this isn't a contest, this isn't a game, this isn't who wins and who loses.
Yeah, it is.
This is about justice. You know, Oliver Wendell Holmes, one of the justices of the Supreme Court, once said, jury duty is the highest duty a citizen can perform for their country in peacetime. Because you are protecting us from them, from the state, from the government. That's the foundation of our Constitution.
I'm already thinking, wrap it up, guy.
The right to be presumed innocent.
This spoon is getting dry.
Jury trial has a right to have his or her peers sit in judgment of him. That's you. And the framework is you presume him innocent, and you cannot convict him until the state proves to you beyond a reasonable doubt of his guilt. And a reasonable doubt is the kind of doubt which would cause an ordinary person to hesitate to act in the more important decisions in their life. Now, what makes this even more complicated is there's no direct evidence. There's no eyewitness. There's no camera. There's no fingerprints. There's no forensics tying him to the crime. None.
Because that's required.
Without any fear of contradiction whatsoever. None.
Because you know the evidence.
And what the judge is going to tell you is, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. Now, this smoke they've created is about suspicion. I mean, if you show up at the scene,
he hasn't said anything of importance yet, really.
Especially dead, and the guy's got a shotgun. You know, it's pretty logical for the cops to jump to a conclusion. He did it. And the problem is that as they came to that conclusion, they have pounded that square peg in the round hole, and you're going to hear about it. They've ignored some witnesses.
Don't peg anybody ever for anything.
For instance, that blue tarp with the
whether it's round or square.
Blue tarp.
You know, the prosecution experts had some pegging done.
That witness who said he showed up with a blue tarp was shown a blue rain jacket that he talked about. Said, that's not it. That's not what he brought here that morning. I mean, I've talked to her. She says, no. It was a blue tarp. And what was it?
Oh, shit.
That would indicate
Uh-oh. Sustained during an opening.
Oh,
I would tell you that the testimony you're going to hear is inconsistent with the Attorney General.
objecting during an opening is
Based on
really,
interviews done
really
by-
frowned upon. But the fact
So-
it was sustained is
What
brutal.
I'm telling you is this.
Very rare.
As you sit here and listen,
Usually you can say pretty much anything you want in an opening statement.
every time there's a witness that takes that witness stand that the state's put up there, you see, you judge the credibility, whether to believe a witness or not believe a witness, whether to believe one witness against many, many against one. You're going to have to evaluate the testimony you hear from this witness stand with a critical eye. Critical eye. I mean, if you've got uncontested scientific evidence, you accept it. I've got no problem with that. These cell phone records he keeps talking about, I would say to you, are not necessarily accurate to the extent they're reliable. I will also tell you that there's going to be a bunch of people, and I will have been promised something or threatened with something that may take the witness stand and say something. But I tell
It
you what,
looks
they're not-
weird to have his hand in
gonna
his
say
suit
anything
coat
wrong.
pocket like that.
They're
It's
not going to
bothering
say that they were involved in it. They're not going to say anything.
Yeah, what is he
that would
hiding?
give you a comfort level in their testimony.
I mean, it's not his pants pocket.
All of you have indicated that you will follow the law. And I say this,
We've got a Steve Gosney sighting. What's up, Gosman?
he didn't do it. He didn't butcher his son and wife. And you need to put from your mind any suggestion that he did. You've been picked because you said you could be fair. You were picked because you said you could follow the law. You were picked because Alec Murdaugh believes that you can be fair. Now, if during this process over the next however long we're here, I say something or do something, which most certainly based on my career, I will do, that irritates you or angers you. Sometimes I'm a little rough. Don't hold that against Alec, hold it against me. If I say something that offends you in some way, don't hold that against Alec, hold it against me. Remember, as you sit there right now, in your mind, he didn't do it. He
Should have focused on that
is
in the beginning.
innocent. He
Yeah.
would require a verdict of not guilty from you.
Should have focused on that.
That's the law.
Yep. And then
That's
told
your
us
hope.
why we should think that way.
Thank you.
Okay.
Wow, I did not like that at all.
Gosh, that was weird. That was just
Yeah.
That was just weird.
Ladies and gentlemen, I'm going to send you to the jury for room for a break while I discuss scheduling with everyone. Please do not discuss the case. As I mentioned to you earlier, you're not allowed to discuss the case at all.
I mean, he emphasized, oh, we got him. We got the guy. Then, oh, you know, I might make mistakes and I might say stupid stuff. That's all I got out of that.
Why?
That's weird.
Why did he bring that up? I don't understand. I don't understand at all. All right. So let's talk about this a little bit, Jeff. You know, and I've got the coverage pulled up here, so I'll just remove that for a second. So in the poll, by the way, I put up a poll. Who did it better? We have only 218 votes. What the? We have almost 700 people in the chat. Guys, vote in the poll. Who did it better, the prosecutor or Dick Poon? Who did it better? Who did you like better? Did you like the Poon better? You like the prosecutor? And I'll cover these. By the way, I'll cover a couple super chats here. So, by the way, Zadok's attack at first said, "Lol, your stream is 2 seconds slower than Rackets," and then followed up with, "I was wrong. The YouTube app on my phone has a delay. The trees don't cantilever; they lean." Very, very true.
Yeah.
Wait, hold on. Coverage is
Cantilevering
back.
trees.
For scheduling, do you have a witness you want to call today?
Your Honor, I think as we have talked to your law clerk, I mean, we do have a witness. Unfortunately, that witness, the main point of that witness would be the body-worn camera, as he is a first responder that arrived at the scene.
unfortunately, the audio does not appear to be working, so I'm informed, despite efforts of courtroom staff and even our IT folks to try to get it going. I've been also told that the company that installed this for the court is not here, and they've been able to do this. So, unfortunately, given the lateness of the hour, which I don't think we could finish them anyway, because the video in and of itself is fairly long.
9:30 tomorrow morning, they still haven't done whatever you just said.
I will personally come up with a solution to present evidence to this jury, but I think, I don't even think we could really get him done today anyway if we started, because even the body worn itself is 20, 30 minutes.
Hey, Steve.
Which exhibit we put in.
Welcome, Steve. Thanks for coming.
John, I think this is wise because even if we started right now, I don't think you could get the whole video played.
Dick Poon's trying to end it here.
Gentlemen, now we're going to have them play the whole video rather than picking out.
No, his real name is Dick Harpootlian. So same thing.
I'm calling him Dick Poon. I'm sorry, Jeff.
We
That's
had
my name.
prepared excerpts. There's a lot of discussion of law enforcement as they're arriving at the scene, and I have theories. But if you want to play the whole thing, I'm fine with that.
That settles that. Okay. If you bring the jury, I'm going to excuse them to 9:30.
All right.
Woohoo! I can sleep for 2 hours.
We're calling it.
Yes.
There we go.
All they've got out of that was
welcome, Steve. Welcome, Steve.
His son's brains were blown all over the building. His son's brains were dripping from the ceiling. They were in a lump by the side of the head. The wife was brutally murdered, shot in the face and the chest or whatever. And thank God we got the guy. And I might make mistakes as we argue. That was a weird opening, I thought, by the defense.
I mean, if you want to go reasonable doubt, just go in on reasonable doubt, focus on their burden, focus on how much they have to prove, focus on the circumstantiality of the evidence. But he was all over the place, and he came off as kind of a rambling boomer.
Can you hear me?
Seriously.
Yep.
Yeah, you're fine, Steve. You're fine.
Okay.
Did you listen to it, Steve?
Yes, I did.
I've been
listening. Well, I've been listening. I'm not as down on it as you guys are. I thought that the prosecutor was a little better. I have a lot of thoughts on some of the evidence that we expect to see. But as far as the defense attorney's opening, I think it was okay. I think it was good. It was sufficient. I wasn't as negative as a lot of people seem to be saying. I think the prosecutor was slightly better. He was more energetic.
Yeah.
My thoughts are in comparison to the prosecutor.
Okay.
And as well as, this is a state senator who has extensive experience apparently in murder and death penalty cases.
And probably because he's a senator, public speaking in general, and you'd think he could keep people engaged. And frankly, forget about it. Think about it on a lizard level, like a basic, a basic lizard level. Who was I paying attention to more? Who was engaged with? If I ask myself that, it's the prosecutor.
Okay, that's fair, and that's sort of one of those stylistic points. I'm looking at it more as a technical thing, and
sure.
I think it was a little bit long. Could have been a little snappy. I thought he used the word innocent, which you shouldn't do. It should always be not guilty. The state has the burden beyond a reasonable doubt to prove him guilty beyond a reasonable doubt, and that they cannot do. When you start saying innocent, now all of a sudden that's a burden shift back on yourself.
Mm-hmm.
I think that was a slip. I think that there was a little too much hooing and hawing and qualification and sort of, oh shucks, I'm the guy. But he did point out it's a circumstantial case. There's no eyewitness. He was framing the case the way he wants him to see it. And it was a little long. It could have been a little snappier, but this is South Carolina. They're a little slower talking. So I thought he was okay. I think the state was a lot snappier. Now, I was listening and not watching a lot of what you were doing, but the evidence, obviously the motion in limine regards to the firearms matching was obviously not granted. So this is the reason it was done pre-trial, was so that the state could bring it up in their opening, which they did. So I'm assuming then, therefore, without objection, that they allow that in, and that is error. I think that is a reversible type error that has been placed in this case already. So that's a problem.
At the end of the day, what the judge said is, I think it's important for the jury to see this evidence and make a decision. So he let the expert in and the evidence in.
Yes, but he's going to let the expert testify that the bullet casings that were recovered at the property that were ejected by the 300 Blackout AR rifle were a match to the ones found at the crime scene and were fired from the same rifle. That they cannot do. I heard a lot of puffery. I listened to the qualifications because this is an issue I'm very interested in. In fact, I'm going to go rewatch it and re-listen to it because I want
the motion eliminate.
The motion eliminate on the firearm matching. Everything's cool up to the point where he says this shell casing recovered from his property, the 300 Blackout, was the same firearm as this one. See, here's the problem, and we talked a lot about this. Vices and I did I came in during lunch because this is one of my little pet issues. Right?
Yeah, this is it. Yeah, this is it. This is your issue. And by the way, this is how it works in the law. Like lawyers, we have our issue, right? We have our pet issue. And when someone touches your pet issue, you're like, oh hell no, I gotta say something about this. So go ahead, Steve, preach.
Yeah. Well, so you know it, all right. So that's exactly your mindset's got right on. Yeah, this is one of my pet issues. In fact, my book is full of my pet issues. And the thing is that this would be a chapter in my book, but for
by the way, well, hold on, Steve. This is the first time you've been on my channel. Can you introduce yourself real quick?
So it is.
Know who you are, your qualifications. This is your first time on my channel, so introduce yourself, please.
All right, here, let me get my book. I got a Grift, right? I am the author of Ideas and Answers in Law. And did I send you a book, legal license?
No, I have to give you my address.
You need to send me your.
How do you get one to Jeff? You sent one to Jeff?
I did.
I've got two.
You get
what? Okay, I'll give you.
I hold the record for grifting the most copies of his book in a single night. Nick took like 8 hours to grift 40. I grifted 54 of his books in 4 hours.
Yeah, funny. Yeah, Nick did 42 in I don't know 8 or 10 hours or whatever it was. That super long one. And then Vices, of course, it was like all about selling my book, and that was so nice. So I sent him another book. But he did 54 in 4 hours, which was amazing.
Nice.
So so if you guys don't know me, my name's Stephen N. Gosney. I'm a assistant public defender doing criminal appeals in Florida, and I've written a book on law and issues commonly dealt with issues in crime, in criminal law, and you can buy the book only at crimelaw.net. And I also have a Rumble channel. I'm a frequent commentator on things that I have something to say about. I don't like to just come on and like look at my mug because it ain't so pretty. Like you guys, these guys are much prettier.
I like looking at my mug. I love looking at my mug. And Vices is obviously down for looking at his mug and while drinking. So it's all good. But hold on. One thing, Steve, is that you're an assistant public defender, but I want to make that clear because just like when I say I was an assistant general counsel, and I have to explain that's every lawyer but the top, right? But the elected official, right? In that case, right? So and when I was working for a corporation, every lawyer but the general counsel was an assistant general counsel,
right?
So that does not mean you're not experienced. In fact, you're very experienced. In fact, you're relied upon for very high profile cases. In Florida, particularly at the appellate level, which is really something that comes in terms of knowing what's appealable and what's not. So when Steve talks about appealable issues and how Murdaugh may be setting up for an appeal, I would listen up.
Well, yes, and and I'm always looking for that error. So I'm also board certified criminal trial law 3 times. So I've been board certified for over 12 years in criminal trial law. Which is interesting because I do appeals, but I also help out our trial division on high-profile cases. I do a lot of strategizing. Anyway, I have some knowledge of criminal law. The thing is that this is one of my pet issues, and that is the oh, wait, one more thing. We got a grift here. I also teach criminal law and criminal procedure for Andrew Branca, who's on my my book here. He wrote my foreword. So if you haven't gotten the book, please do. I know this is my first time on here. Thank you for letting me on. So if anybody doesn't know me or hasn't gotten the book, it's the only place you can get it is from me personally. So, but what were we talking about? Oh, so there's 3 things that I heard that are fascinating, and this is just so in my wheelhouse. You have no idea. The first is we have gunshot matching or firearms matching with the casings. BS science, you can't do it. It's let in. That's an appellate issue. All right. If this guy was qualified, I couldn't stand it. I was listening. I can't. I was like,
So are you telling me, Steve, are you telling me you cannot match a bullet to a firearm? Completely impossible.
Well, let's roke it to this case. Oh, well, here, and I'll explain it. I'll explain it very easily and simply for the pro-matching folks can disagree with it. That guy was saying he's Mr. Science, right? He follows the scientific method. Now, what he described was not the scientific method. He's saying, I have a theory. The theory is that this is a shell casing matches this firearm to the exclusion of every other firearm in the world. All right. So part of science is you have to be able to be falsifiable. His falsifiability was, I get another guy that's trained in exactly the same technique to agree with me. That means it's verified. Now, you as a scientist, how would you ever disprove that theory? How would you ever disprove?
Oh, hold on. Sorry, the judge just sat down, so I assume they're gonna.
Okay.
You can bring the jury in.
Okay.
Oh, they got a witness.
He's going to excuse them for the day.
Well, that or they're excusing.
He said he's going to bring him in and excuse him because it's 5 o'clock there already. So it's 5 o'clock where you are. So.
Right. MG Law has it right on the money. You can match a bullet to a particular type of gun. He can say this is a 300 blackout shell casing. He had a 300 blackout rifle. There's one missing. All that, which is great
circumstantial evidence. It's not definitive, right?
But to say that this casing that we found that was fired, that he fired, matches to the exclusion of all other, because there's no way to falsify that. You basically, in order to falsify that, you would have to have a database of every other firearm barrel with a shot out of it, or with a casing fired out of that receiver, right? There is no such database.
That's why we have to approve that for the federal government, Steve. We have to allow the federal government to create the database of all firearms, exactly where they're stored, exactly where all the ammunition is. We need to allow the federal government to do that, Steve. Why not?
Yeah, exactly. I don't believe in it. I think we should have a law for the Republicans take over, the pro-gun folks. They need to have a law that immediately has.
Ladies and gentlemen, we are.
We'll sit in it. We'll come back.
9:30 tomorrow morning. Remember the oath that you took and the instruction.
9:30 a.m.
To discuss the case with anyone. You're not to engage in any search
shenanigans,
further details,
shenanigans
through any means. And we need you back at 9:30 tomorrow morning, following the instructions given to you by the bailiffs as to where to report to. You'll never come through the courtroom to get to the jury room. And we'll see you at 9:30 tomorrow morning.
All right. Well, gentlemen, I'm going to take this opportunity to scoot out the door so I can get at least 2 hours sleep before I go to work.
All good for you, Vices. Thank you so much.
I'll be back at 9:30 a.m. Eastern to kick it off. And then again, when Legal Mindset wakes up, he'll jump on her sometime during the lunch break.
Yeah, I will.
I will. And switch it on over here again.
Yeah, that's my plan. My plan is to try to, go to bed early, wake up, jump on with Vices, stay up all night with you guys, and bring on good guests like Steve Gosney, whoever else is up, awake, conscious, paying attention, has a pulse. We'll bring them on and talk with them, especially if they have something to say, and especially if they're experts like Steve. But Vices, thank you so much, guys. Follow Legal Vices. Make sure you subscribe to Legal Vices. We're doing tag team coverage for pretty much all the trials for the next couple months. So make sure
you're on a trial train.
You want to make sure you get the front half and then you get the back half. You hit it from the front, that's Vices, and the back, that's the mindset. Keep it legal either way, and we will see you tomorrow for this case.
Take care, gentlemen.
Peace, brother.
Bye. As soon as I can get the wherewithal to click out of here.
You're good. All right, I got him. And by the way, let me just get some of these super chats here, clear some of these, and we'll let you rant here. Let's go. Brandon says, this is a horrific opening. I said it from the jump. This lawyer is too old. The good old boys are going to lose. And then a lot echoing that statement. So you have Wild Red saying $2 crap opening statement. Nicholas Starro, Union Rep Law, says, I've never done an opening statement, and I am sure I could wing a better opening. Presumed innocent. Their evidence is inconclusive. Loving marriage. They never looked at other alternatives if the glove doesn't fit. Yeah, a lot of people not liking that opening. Flux says, all I can think about is the kid's exploding head, which was the honestly the detail he focused on the most.
Which as a defense team, I don't know if I'd do that. I think
it's a bold move, Cotton. It's a bold move.
And I think though, but there is a point. I think it was the one just before this about. I think there is some hay to be had that this was his wife and son. And so for the father to do that to his wife and son, this brutality, it's hard to comprehend and unbelievable. So that is sort of a reasonable doubt thing. You could say there's circumstantial evidence here, but would a son really, or a father really do this to his wife and son? I think that's a good argument. Now, emphasizing the gore, I don't know. I don't know what the evidence is going to show.
I would focus on him being a loving father, maybe
Right.
a love, like focus on the loving part, not on the gore. The gore is like what might even convince you on the other side, right? So I would just stay away from that. I don't think that's necessary. Maybe you just say, gruesome once and just leave it. But talking about,
And
exploding body parts, no.
It's not gruesome until it's over either. So, I don't know. I'm just
Well, the jury is probably going to see it. I got that question from the chat, right? I mean, they'll probably, at this point, both sides have talked about it. They're probably gonna show some of the crime scene.
Well, Michelle says that there was a mention, and I didn't hear this, but that they might visit the crime scene. Is that true?
Well, if that's true, if they're taking a field trip, that'll be very interesting. They mentioned that. I don't know whether they actually will or not, conclusively. I am not sure. That would be interesting. I don't think they could film that while they're visiting the crime scene. I mean, I guess it's possible, but
I'm just wondering how that would work from an appellate standpoint. Well, back to the firearm, the shell casing.
It creates by the way, Steve, I agree with you. That creates, I think, more appellate issues than it's worth.
And it's preserved. It's preserved because this was argued. He got a ruling on it. They put it in the opening, so it's going to be a feature of the trial, and it's a circumstantial case. So it's not like it's harmless because there's all this other evidence. So I really I don't think that was a smart move for the prosecutor to go be that aggressive and get that matching thing. He's making a mistake by relying on this. Now, here's the problem. Scientifically, in order for a scientific theory to be science, it has to be falsifiable. How do you ever falsify his conclusion that it's a match? How is that falsifiable?
I guess, yeah.
You'd have to have a database of fired shell casings from every 300 blackout receiver
to search against.
Search against. There is no such database.
Yeah.
So it's not falsifiable. So that if it's not falsifiable, it's his opinion. It's not science. It's not a match. You can't say it's a match. Now you can go so far. You can go, there is, like when it was not credible when he was saying this technology has been around for 100 years, as long as firearms. Okay, yes, that's true. But this idea that if you get a microscope and you look at the shell casing and you look at the extractor pin and it creates a unique extractor for every shell casing it ejects, that's not been around for 100 years. He's mixing apples and oranges. That is, and then his appeal to authorities, like we have these published journals. The published journals he's talking about is the organization of people that do this, that believe in this technique. It's not the science. The National Association of Forensic Scientists, which was the report he was talking about, which I talked about in Vices, that report is science, and they say these assumptions are not valid. So I am very much disagreeing with this decision, and I think it's appeal issue number one.
It's not like we've never seen industries making up their own science and saying it's valid for the purpose of profit. That's never something that's happened before, where industries have self-validated through their own journals. That's never happened before, ever.
And I was talking about Vices this morning about Chris Fabricant. Do you know Chris Fabricant? He wrote a book called Junk Science. Yeah, and he is.
I think I've heard of that book actually.
He's with the Innocence Project. And he talks about how bite mark evidence wrongfully convicted this person. It's the whole book is basically about this. They became this bite mark experts and these dentists, and then they had this association and they had a journal and they published papers about how they can match teeth.
Because they can make money on, and it's the thing, like if you can make money on it and you can get enough people to back it up, because they want to make money on it too, you can make it a thing. You can force it a thing. It's so-called peers that all have an interest in promoting the issue, so they promote the issue. If you're able to get enough of those people, you can make it a thing, right? You can, and that's how you end up getting experts and counter experts. You get people that have made up this thing and people that disagree with the people that made up that thing.
And the state, they love this kind of thing. They love this kind of stuff. And it's taking it too far. It's a step too far.
So we watched, Steve, well, you'll love this. So I was watching a while ago because of the new Casey Anthony allegations in her documentary, the Peacock documentary. I was rewatching Casey Anthony, and remember the sniffer guy, right?
Oh, the scientific sniffer.
The sniffer. Yeah. He's now come up. His new thing that he's come up with this year is divining rods. He thinks that metal rods can find bodies. I mean, this is,
you know, but
it
used to be, people would use divining rods to find water. Dig here, right? That was science. Sure. You got, you know, we're talking about somebody's life in prison, life in a cage, based on your legal conclusion on something that is not verifiable and non-falsifiable. That is not science. It is not science. And so, and for them to say it's science and it's certain is a mistake. And that people put a lot of credibility, like DNA is very strong. Fingerprints is right below DNA. I would say fingerprints is also very strong, depending on some, it's a little less certain, it's a little bit more, but those are kind of the gold standard. This tool mark stuff is garbage, and they've got to limit themselves to what they can say. It's, you know, the firearms guy. Yes, this is an operable firearm. Yes, this is a 300 blackout. Yes, this casing was fired from. The murder weapon was a 300 blackout. He has a 300 blackout. There's a missing gun. I mean, all of that's great circumstantial evidence. It's going too far. The next piece of evidence I want to talk about.
Well, they've got to put that together, right? Here's the thing with circumstantial evidence. You've got to put that evidence together and say, hey, this evidence together makes him the person. This is why we're putting, and that's for the jury to decide, right? The jury, that's for the fact finder to decide the credibility of the witnesses, the credibility of the evidence, if we can rely on this, and whether reasonable doubt has been satisfied. And in most cases, you know, frankly, I believe, and I do have a prejudice towards reasonable doubt. I do tend to believe that circumstantial evidence should generally lead to a not guilty outcome. But, you know, there are circumstances where they judge the credibility of those witnesses, whatever's on the stand, and they say, hey, look, this does add up. We can convict on that.
Well, the circumstantial evidence rule, which everybody's been referring to, is really important as a protection for the actually innocent. And that is that if the case is wholly circumstantial, case is wholly circumstantial, then you can posit a reasonable hypothesis of innocence, then that should be not guilty. So that's kind of the circumstantial evidence rule. Now, there's been people, you know, why this resistance? Oh, we got to let one person. If one person gets away, then the system has failed. That's the opposite thing. The state has the burden to prove beyond a reasonable doubt. That means some people are maybe guilty, probably guilty. Oh, they did it, but they got away. That occasionally happens. There is imperfection on the system, but we should err for imperfection on the side of not guilty rather than guilty.
Yeah. And Steve, I think that's when people get confused here. They think, oh, well, you know, because Andrew says he really liked the prosecutor's opening and not the defense, that he's biased towards the prosecution. I'm like, no, actually, if anything, I'm usually heavily biased towards the defense because I believe in due process. I believe in not guilty until proven innocent strongly. I believe that's one of the things that makes our country great. If you look at a lot of other countries, including the country I'm sitting in right now, South Korea, the prosecution rates are ridiculous. They get a 95%, 98% conviction rate. Same across the bay in Japan. Don't even talk to me about the CCP. You know, I mean, you're in other countries where you don't have the due process we have in the United States. And I believe that's one of the most valuable things about our system. So the prosecution still bears the burden of evidence, but I can say the prosecution has that burden and that their case is circumstantial, but also they did a better job technically on the opening, right?
Yeah.
Those things are not mutually exclusive. You can say both, guys. You do not have to stand for, you know, to stand for one side so hard that you can't acknowledge when the other side does something right or when the facts are what the facts are. That is what it is.
Perfectly
right?
said. Beautifully said. Exactly right. Like
let me read these two other, by the way. Buy book shot ratio.
I'm at home, so I can drink if that's a thing. I mean, it's your channel. I don't want to take.
We can drink whenever we want. I mean, it's up to us. It's our discretion. But I'll leave it on that one because I've taken 2 shots already and I'm feeling a pretty good buzz. It's 7 a.m. in the morning. Durna said, if he hired someone to do it, then the prosecutor is going to look like a binger when the theory he did himself conflicts with the direct evidence. Well, that's the thing. I think both sides, to me, Steve, both sides came in hard on their theories. So the prosecution has come in hard on Murdaugh himself did it, and he didn't hire somebody to do it, right? They've they've gone all in on that. And on the other side, they've gone all in on this was so gruesome, and they described it now and gone through how gruesome it was, that there's no way that Murdaugh could have done it because it was so horrible. Only a monster would do this. So they've both kind of taken this all-in sort of approach.
Yeah, but see, I don't like that from the defense side because it's too much. I think you're putting the burden on yourself. You're bringing too much over on your side. I mean, the best thing that we have going is that burden of proof. And by being so aggressive and so certain the way he's doing it there, I don't know. I mean, he knows the evidence better than I do. It's his case. But I'm a little suspicious about that. And if we're going to drink, you've already sold one book, I must say. So salute to you.
Oh, I have. Absolutely. That is possible. That is great. And if we're talking about media, let me show my own media here right now. I haven't talked about this on a big stream, but I am working with a team on a manga. If you guys are interested in anime and if you're interested in a law-themed anime with law-themed waifus, check out Adjudicator's Academy on Indiegogo. The first volume is going to be called Nozomi Hatter in the Philosopher's Grift. We've already got the first chapter done. We're going to have at least 6 chapters in the first volume. It's going to probably, the first 6 chapters will go no matter what. If we hit our goals, we'll get more. But guys, go check that out. You're over on Indiegogo. Link is in the description. You got your based waifus. You got law references. It's going to be law jokes throughout. Great stuff.
What adult rating will this have?
This will be, well, the initial cut is going to be R-rated for sure, but there will be definitely the potential for side stories, which we can talk about. We can talk about other ratings when we get further down the line with development here. But at least there's going to be, specifically if we hit certain goals, there will be a swimsuit episode for sure.
That's so funny.
There will definitely be the beach episode if we hit certain goals. But guys, check that out over there on Indiegogo. That's a project that I'm working with. I'm not the artist, but I'm the Schiller in chief. So go over check that out on Indiegogo.
How much for the NC-17 buys?
Well, if we get a certain amount of people, it'll get there eventually, right? So we get enough people, we'll get there. We get pretty much maybe a couple hundred backers. We'll get there.
I'll make one more grift too. If the drinks are on the table, the rule is 5 books per shot or drink or whatever 5 books.
Can you private chat me your book link so people you have a direct link to buy the book so I can show that out there.
Well, it's right there on my little thingy, crimelaw.net.
Okay, crimelaw.net. There you go. Crimelaw.net with Stephen Gosling.
Not available anywhere else but from me because it's it's not like people are. You know how much Amazon wants to take all my money for all the work I did for
I know.
Years of my life.
You work so hard and they take all your shit. Same thing with YouTube, right? I mean, they take a third of what we get, which is why you guys should go over there to mylegalmindset.locals.com, which is where you get the best coverage and also the best memes.
And I'll also say, we should put something. We're really going to play it. I have more stuff to talk about. We'll talk about it in a second.
Oh, absolutely. Yeah. Hold on.
But if you go, let's set a goal by which you get a hardback because, there's only very few of these. Let's see here. Very few of the hardbacks. So I'm going to send you send me an email with your address.
I'll send you my address and you're going to get me hard and we're going to be great. So guys, get hard with Steve Gosney. Hold on. No, okay, I got to earn it. I got to earn the hard. Guys, get me hard. Guys, out there on the internet, get me hard for Steve Gosney right now. Go to crimelaw.net, get Steve's book, 5 copies, and I'm going to get hard. So, get me hard, guys.
I was going to put the bar at 10.
Okay, fine. 10 to get me hard, guys.
10 books and you get hard. Otherwise,
you guys know you can get me hard.
It's soft for you. You're just soft.
Yes. Speaking of hard, you've already been memed. This is how quick it do.
Oh,
Steve Gosney, South Carolina people are slow. Oh, Steve.
Oh,
Steve.
No, I don't want. I'm a Southerner, man.
Yeah, you're in Florida. You're over in the Daytona Beach area, right?
Although they say that Florida is the only place that you go south to go north.
Yeah, I'm from Miami, Steve. I think you probably know that, but that's pretty much another country.
Yeah, that's Yankeeville. That's like between New York and South America.
I was going to say, I'm in the South America part. Like the Yankee part is Broward County with the liberals that are down there. That's
the condos along the beach, you know.
Nancy Pelosi's condo. That's the blue voting territory. Miami voted red. Thank you very much.
Yeah. Congratulations. That was cool. Well, so I think we've covered the bullet matching or the casing matching kind of in depth. I did want to talk about some of the other evidence that they may be discussing, right?
Sure.
And that is the second thing was this gunshot residue. All right.
Mm-hmm.
Now, here's another bit of, I would say, BS science. Now, here's the thing. Gunshot residue, in fact, as much as like the FDLE, the Florida Department of Law Enforcement, does this shell casing bullet matching thing. They have the same organization. So I've seen this guy before. You know, it's the same testimony, all right, which is garbage. But the FDLE, Florida Department of Law Enforcement, no longer does gunshot residue testing. They don't even do it. They have to go private. Now, why don't they do it? Because it's meaningless. All right. All you are proving is that this guy's got guns. Okay, well, or has been around somebody with guns. You had gunshot residue on you. Well, no kidding. I've got gunshot. Let me tell you, if you tested me right now, I got gunshot residue.
I was going to say, we probably, like, especially when I was in the U.S., I definitely had gunshot residue. I was going to the range often enough that, and you know, between that and cleaning my firearms, like, I definitely had gunshot residue, like, all over.
Right. Yeah. And you talk to a cop. Cop's got a gun on his hip. He touches his gun and then shakes your hand. Now you've got gunshot residue on your hand. I mean, there's so many ways. In fact, and it's the time, you can't narrow it down. It could have happened 8 hours earlier. And so it's basically gunshot residue is whenever I hear that, I'm like, what are we trying to prove here? To me, it's reach evidence. I'm very suspicious of that. Now, it is true that these certain particulates are a formula that come from gunpowder, right? But what is it proving, really? I mean, it's not proving anything. You have a gun. Okay, that's not illegal. I've been around somebody with a gun. I shook somebody's hand that touched a gun. It proves nothing. All right, now they're saying that this thing. I mean, I'm very skeptical. I'd like to see how
it's circumstantial evidence. I mean, you've got to put it all together. Now, I will say, Steve, if you put a bunch of small evidence together, that can add up, right? Like if you put a bunch of small evidence together, okay, all of these things, okay, yes, that one given thing, it's high probability. A lot of people have that, right? Like you said, cop touching a gun, somebody going to a range, he's out there hunting deer, right? The probability is high. But when you put together these things, what the probability of all of these things occurring at the exact same time? If the prosecution is able to convince the jury of that, I think that'll go better for them.
Okay, well, here's what I heard, and this is number 3, and that is the cell phone coverage.
One, and by the way, let me bring that up. This is one I've been covering the Idaho stuff. I don't know if you've been following that at all.
Yes,
but the Idaho cases, the same thing with the pings. And shout out to Andrea Burkhart. She did a very good job of covering this as well. From a defense standpoint, that those pings can cover a lot of people. Just like having cell phone towers that are covering, saying, okay, there's these 3 towers are covering. There's probably in any given moment thousands, tens of thousands of people that are covered by those pings that are within the same zones. Does that mean they're guilty? Yeah.
Hold on a second.
Okay. Yeah, sure. So that's something that's very suspect. You're not able to say that, hey, because this guy's cell phone was in this general area, he did it. No, it means he was in that general area. It's a triangulation. Sometimes if there are 2 towers, and I was speaking to somebody who's an expert on this, if there's only 2 towers that are kind of pinging, then the range could be absolutely massive. Could be this entire town. Steve, you're muted. Unmute. Yes.
So the wife just came home. Hi, Mom. All right. So it's this one that you got to be careful of. It can be very powerful circumstantial evidence. Okay. And I'm not certain about the distances between his alibi witness, the mother's house, and where the murders occurred. So what we're going to talk about is timing. So was his cell phone active in the areas of the murders at the time, and then they can track it to the area of the mother? Is that distance great enough that cell phone tower coverage will be significant? Because like you said, what happens, the mistake that's made is they'll locate these cell phone towers and then they'll draw circles around them. All right. That is not the way cell phone tower maps work. It's not the way the technology works. We've done a lot of classes. I've done a lot of classes on this from a defense perspective on challenging cell phone things. The way it is, it's very muddy. It's very difficult. You can do a direction and you can do a tower, but to do a circle, if you see those circles, that's garbage.
Right. The Venn diagram looking thing where they
Right.
have 3 circles and they make a Venn diagram and they happen to it happens to be over that certain area. That's not how that functions.
But now,
right?
but
It's
what
not.
they're saying, that's right, exactly. Now, in here, and I don't know, we haven't seen the evidence yet. This is going to be a good case. Is he's going to be making statements to the police on the body cam, right? From what I hear. So he's reacting and he's going to have his alibi, which is his mother, who his Alzheimer's conveniently, right? Where is that located? He's going to say he was there the whole time. But yet, are we going to have the cell phone coming out of his pocket from the cops, and that cell phone tracks back to the murder location or a cell tower within the murder location that can be isolated from where he was ultimately arrested? Can that be done? I think what they can show is that he's lying about his location, that he was there. So that is very difficult type evidence. You see, I mean, that to me would be the best circumstantial evidence of the 3 that we've discussed, right?
Right. And now I've heard some people say, and I was speaking with a law enforcement agent the other day, and I was saying that, and they were saying that some services, some providers, right, provide very, very specific, accurate data on location. That they'll say, like, for example, if you talk to T-Mobile, I believe it was, that they have very, very accurate data. Have you seen that? Have you seen, from the defense side, them trying to enter in very specific location data?
Yes. Well, and this is the thing. I mean, there's what can be shown and what cannot be shown. This is where we get, if you have the cops and they get the cell phone tower data and then they draw these circles, bad. Okay.
Right.
You can get experts who can testify about that. Like, I don't know. I've seen this stuff in so many cases. I've seen the cell phone, and it'd
be different if it was connecting to like a Wi-Fi router or something with like a shorter range.
But you can say a lot with if the mother's house is 10 miles away,
right,
and you got a cell phone tower that pings, and then all of a sudden it handshakes the towers all the way to the mom's house right after the timing of the murders. That's pretty good, you see,
right.
And that's very circumstantial evidence of guilt. And then they find the cell phone on him, so he possessed the phone. They've got him very close in time. I mean, that can be very tough evidence. The missing gun, and then and this is a very interesting case. I must say, I'm intrigued by it in that it sounds like there's a lot of reasonable doubt. How much the state can prove with the circumstantial evidence, I'm not certain. We'll see, right?
Yeah, and some people say in here that 5G is closer than other forms, right? And I think that's based on the nature of the technology, right? Because that requires closer.
Well, I'm sure this guy's going to have an expert witness who's going to testify about the cell phone coverage and what it says or what does not say. It sounds like he's got a gold-plated defense team, right? So, we're going to hear expert testimony about the limitations of cell phone coverage, I would expect, and that'll be great stuff. I love this. Is like you say. I mean,
I'm ready for it. This is like a field day in terms of evidence, in terms of what they can prove, what they cannot prove. And I said it before. Like I'm pretty convinced they can prove the financial crimes. Right, because those are super easy in the elements, right?
Did he speedy trial this? Did he speedy trial this one?
I don't have to check. I don't think he speedy trialed the murder side.
Yeah, well, because my question here too is, why is this case going first? And my understanding, usually what prosecutors will do is load them up with years on their strongest cases, and then play him out on the stuff he's already in there for 100. So who cares? I mean, it's not a death case, right? This is a straight life case.
I believe it's a life case. Yes.
So
yes,
I don't understand why this one's going first. It sounds like there's some weaknesses in the case, but we'll see.
Yeah, we'll see. I mean, once again, we got to see what they produce at trial, what we actually see, and what's admissible, right? I mean, they may try to admit it and they may get rejected, right? They may try to make the statements, like you said, that hey, this came from this gun, and we're going to see that one getting swatted out of court. When they try to bring that up.
I think MG.
By the way, Well, I'm laughing here. Somebody put this meme from Joe Neerman, my good friend, by the way. I'm going to be on with Joe tomorrow. Circumcisable evidence. I love you guys. You guys are
Yeah,
I'll be on with Joe tomorrow at 10 p.m. By the way.
MG Law is funny. I think he's a lawyer who knows what he's doing. That's kind of my suspicion from reading his chats because he always has the right comment.
Steve, we got a lot of lawyers and we got a lot of people who could be lawyers. And by the way, whether you can or can't be a lawyer, whether you're just a lawtist or you're just somebody who watches all the time, make sure you're smashing the like button here on YouTube, on Rumble, or on Locals, guys, and make sure you're following along because we're going to be here every single day. And this lets us know you like the content, you like having this this channel around to give a different opinion, and you like having guests like Steve Gosney on. Steve must take a shot for every 2 books sold.
No, that's 5 books, and you haven't sold. You've only sold 1.
Only one. What are you talking about? I gotta go buy a book. I'm gonna go buy a book right now just to pump these rookie numbers up. Come on, guys.
See me drink. I don't know.
CrimeLaw.net.
Yes, Crime Law. Is your is this a drinking? I haven't been on your channel.
Well, no, we don't do. Okay, so like, let's explain. I know you're kind of new to my channel. If I do a drinking stream, I clearly label it a drinking stream. Okay. However, if circumstances arise, like the beginning of a case, like Mazel Tov to the opening statement. I had somebody earlier in the chat that said they lost their relative and they wanted to cheers over that. I'm happy to do that. Circumstances dictate appropriate drinking during trials. Will be had. And guys, and I'll be doing that throughout the trial. There's an appropriate moment I'm going to drink, but I don't make it into a drinking stream.
This is going to be an interesting. I'm really fascinated by this trial, and I will say, hey, wifey, hold on a second. She's
you gotta be like, yo, I'm gonna be getting in on this. Look, I am here staying up half the night in Korea to do this stream. So if I can do it and I think it's interesting enough to stay up, I think you guys should be that interested too. Yes. I do think this is going to be a good one.
So what other evidence do we have? We've got the gunshot residue, which
body camera. So body camera. What do you think about body camera and just judging his demeanor, judging his?
That's a hard one. Judging demeanor and saying, oh, he's guilty because he should have reacted a certain way. That I'm very suspicious of, because how do you react when your son and your wife are murdered? I mean, there's no right reaction, is there? I mean, I don't know how I'd react. I don't know. And it's funny because like when I get mean, when I get angry, I tend to smile, which is funny.
Oh yeah. So, I'll laugh. I'll laugh sometimes because I'm just find it hilarious. So I'll just laugh when I'm in, sometimes I'm in trouble and it's so stupid. I'll get, like, for example, I just came back from Singapore and I got that extra screening and I just laughed during it. They like pull me to the side room to ask me extra questions, like what type of, pangolins am I smuggling in? What do I have any, illegal kimchi in my butthole? And like, I'm just laughing because it's funny. Like, it's just hilarious because I'm like, oh, I know I'm going to get questioned this time. All right, let me go back.
I'm a little disappointed in the lack of sales here. Can I sweeten the pot and say that I will, if we do 5 books, not only will I take will drink of your all choices, I'll also eat some kimchi.
You have kimchi on you.
I have kimchi in the house.
Oh, wow, guys, we got a kimchi pillow here, guys. CrimeLaw.net with Stephen Gosney. Make sure you're over there buying that book.
So what other? No, I missed. I got to say I was sort of, I'm trying to do other things. So, and I heard the opening. What is the promise from the state and the openings aside from those 3 bits of circumstance?
The state was very clear. They said they're going to show that this was something that he did. They also made a big deal about the calls and show that the calls themselves were problematic, that the calls themselves were to set up an alibi.
Well, could be, but how do they prove that? How do they know that? What is the evidence of that?
I don't know. I mean, I guess they're gonna just play the calls and you'll see that they're suspects. I don't know. I mean, it's like allow the jury to judge whether it's a legitimate call or a call just to cover his ass. They're going to say that he was executing a pattern of behavior that was abnormal for him. Like, it was abnormal for him to go see his mom. It was abnormal for him to call those friends, that it was abnormal. His activities were not his normal. But the defense argument to that is, it's not normal to have your family killed. So,
yeah, I don't, is that evidence sufficient to put somebody in prison for the rest of their life?
Yeah, I don't know.
I mean, I don't know. So,
by the way, Bass says, Steve, please get started on your second Lifetime work so we can get another book. Yeah, Bass said they already have the book, so they're like, I can't buy another. I already have the book.
I'm working on a second book. Oh, do you want to hear a little bit of story? I took my computer hard drive crashed. It was an SSD drive, a 1 terabyte of information. And my new book, my second book, that is like really going to be great. I can't wait to be able to sell it. And I really want to work on it. Was on there and it bombed and I didn't have it backed up. Stupid me. So I took it to this computer shop. They had it for 2 weeks and were not able to do anything. You know what they call at my last call to them? I'm like, okay, can you fix this computer? Right. Well, we've scanned. This is what they told me. This is a like storefront professional chain computer. We recover your data store. Right. This is what the person says to me. Well, what happens is the software you were using, it scans it and it can read it. And it says, we can recover this and put it all over there. But then it says we have to upgrade to the pro version, which is $109 a year. And because we're using the free version, and therefore we have to pay $109 and we can't do it. I'm like, what? I'm bringing my computer. You've had it for 2 weeks. You're a professional recovery store and you're using the freeware. You haven't paid for the software license. I'm like, come on. So I picked the computer up and I took it to somebody else. 2 weeks. I mean, I haven't been, I'm chomping at the bit. I've got like, I work with these little yellow stickies. I got all these ideas. I want to get this thing done and out to y'all because it's going to be a really good book. In fact, this first book was Andrew Bronca's idea,
Really?
Yeah. Because he wrote the foreword. He said, you need to have something to sell. And I'm like, and I've got all these ideas. I've got about 5 books in my head that I want to.
Well, that's the problem is that everybody's got ideas, but you got to actually put it to pen to paper. And like big on you for doing that, Steve, and like getting it done. And also big on you for teaching. I mean, you're also a fellow teacher. I teach the property class for Bronca. You're over there doing. You're doing evidence or Crim Pro.
Well, I did criminal law already. Crim Pro is going to be coming up. Criminal procedure is going to be in fall of this year, so August-ish. Right now, evidence, and you're doing property, right?
Mm-hmm. Yeah. I'm doing property right now. Very great group, interesting. Like honestly, it's one of my favorite things, and that's my specialty area. So I love talking about it because I've got stories from the trenches.
I've
dealing
actually
with this day to day.
I don't know how much you can reveal, and I'm not going to reveal any of your secrets. But Andrew did tell me about some of your background, about what you did in Central Florida, and it's pretty cool. I must say, I would love. I need to go back and watch your property class. I was a dirt lawyer for 6 years before criminal law. I did,
and a lot of people are, and a lot of people transition out of it, especially because you were in Florida like me. We had a huge boom in construction and especially property law and construction. There's also construction litigation. Like that's very boom bust, right? When things are building, it's kicking. When things are not. But my specialty was a little bit resistant to that because we actually did a lot of refinancings on bad dirt bonds during the downturn. So that actually was really interesting. So even in economic times, we're doing well.
I always liked doing quiet title suits. That was my favorite area. And I love quiet title suits because it's actually like you're fixing something that's broken, which is so unusual in law. Usually you're breaking more stuff.
Let's say Bob said, I don't know who to watch Trump with, you or the Nose. Well, either one, guys. I feel like the parents are getting divorced. So I'm going to pick it a little bit. You guys, listen, I want to say a lot of people are streaming this. I'm streaming this. Emily D. Baker streaming this. Nose, Nick streaming this. Uncivil streaming this. Do who you want, pick who you want, go where you want. Totally fine, your own choice. I would say if you have multiple people you're going to watch different ones on different days. Do whatever you guys want to do. I am a freedom, liberty guy. And by the way, the people that love freedom and liberty, the people that are actually out there, saying make your own choices, they're supporting people who are doing their own content and making their own channels. And Nick is a good friend of mine. Nick and I are buddies. Same, Kurt has been a really good guy. He's been in the chat, and I got no problems with any of these guys. So if you guys want to watch them on one day, that's great. I love and appreciate you guys being over here, and I promise to keep Gibbs coverage as informational and entertaining as possible, and to also be doing as much from a legal perspective, but also bringing in lay people as well to watch and to get their perspective, as opposed to mine. Because sometimes, people like Steve and I, we nerd out. Steve's got his pet issues on the evidence, but Steve is seeing it as a lawyer, and not just a lawyer, someone who's in court normally, right? his brain and my brain work differently than people who know nothing about the law. I can't unknow what I know. I can't unsee what I've seen.
Right. Well, the people's impressions on the openings was fascinating to me because I didn't think the defense was that bad. I was just fascinated because most of your chat and most of your comments have been very negative towards the defense. So, and I've just seen that type of opening done a lot, and I measure it against all the openings I've seen and heard and read, and it's like, okay, that's I understand that opening. That's okay. I mean, I have quibbles here and there, but obviously the jurors are going to be like the people in the chat, not like us. So how they perceive it is very important, and that is like I said, I'm really sorry. I was catching that my connection was in and out on the prosecution's opening. So other than those 3 bits of physical evidence, was there anything else? And
he did a good job of saying the evidence will show, and we're going to prove that this guy is guilty. So these kind of like set it up. He kept it very simple, very quick, very to the point. He explained to you the judge is the explainer of the law. He explained very clearly what reasonable doubt is, and that's not every possible doubt. That's what reasonable doubt is in terms of the prosecution's light, right? Reasonable doubt in the light most favorable to the prosecution, because there's 2 lights, right? So he kind of preempted the defense's reasonable doubt argument by saying, hey, it's not, any possible doubt. It's not aliens coming down, out of nowhere doubt. That's not reasonable doubt. This is what reasonable doubt is. And he framed it in a way that was prosecution friendly, which is fine. That's the point.
That's the point.
That's his job.
Oh,
right.
I know there was something else I wanted to bring up, and that was people talking about objecting during openings. And I am not.
Oh yeah, they did that. They did that, right? And it was sustained, Steve. It was sustained against Poon.
I'm not impressed by that. I've objected a lot in openings, and I've been objected. Well, I've experienced people who have been objected to in openings. I don't think it's a problem. What it is guardrails. Openings should always start as far as the evidence will show this. The evidence will show this, right? And so when you're a defense attorney or a prosecutor, you start rolling, and then you sort of what you want to argue. So it's kind of in the back. You want to set it up, and you want to argue in opening. It's not opening arguments. It's opening statements. And so when you start arguing, the other side will call you on it, and they'll say, okay, this is argument. This is, and you see, it didn't rattle that defense attorney one bit. It was sustained, and he just moved right along. And he said, well, we expect the evidence to show this. And that's all he was doing, was getting a little carried away, a little outside the box, going beyond what opening statements is. And opening statements is, here is what we expect the evidence to show. When you start arguing or start testifying, then it becomes objectionable. So I was not concerned or impressed or surprised by that objection. I thought it was it was sustained. He moved on. It didn't rattle him at all. No harm, no foul. So little different take than I know that you guys had made.
Yeah, but that's fine. That's all the. I mean, I don't run away. Oh my God, Steve disagrees with me. That oh my God. I mean, and I try to think about it with 2 brains: my lawyer brain and my juror brain. Right? Mm-hmm. Like if I remove this knowledge, which I have, which is so hard for people who know it's so hard for people who've watched a bunch of trials. Thinking that these people sitting on the jury have never watched, they're not watching trial streams. They're probably not LawTube enthusiasts, or they're not people who are fixated on the law all the time.
But they should be.
Everyday. They should. You all should be. Yes, you all should be subscribed. It's something that they're just coming at as normal people, and that's the lens which I said, hey, I think the prosecution did a good job of explaining it to normal people, to like regular, everyday, normal people.
No, that's fair enough. And I'm not. It's ultimately it comes down to the evidence. Neither lawyer was terrible. Neither lawyer lost the case in their opening. They both framed where they want to go. I think if I was to weigh it, I'd say the prosecutor was better for excitement purposes, for keeping it short. But and then I had a few quibbles with the defense. But it was, I'd say, if I was scoring it, I'd go 60-40 for the prosecutor.
Which okay, that's fair. I wouldn't say like, oh my God, that's totally crazy that you're going 60-40. I'm like, no, you're saying he won, right?
He edged him out. Yeah.
But it's not like Dick Poon was completely incompetent. No, he did a good one, but it's just we have to say who's better, right?
I voted for Dick Poon because that name. Dick, I mean,
and by the way, guys, I'm going to say it here, no other channel except for me, and we'll see. I think I'm the only one who will call him Dick Poon, but I'm going to make this happen. We're going to make Dick Poon trend on all social media platforms. It's 100% going to happen. Let's see here. Kyle said, just bounce from stream to stream, smashing the like button. Maybe fire a super chat or two at all. I appreciate it. And guys, I would say that's a great tactic. Fire a super chat or two at your favorite creators. Let them know that you like this content because, we like to know that you guys enjoy this type of thing. If you guys hated trial coverage, we wouldn't cover it. Quit Your Bitchin' says, hey, from Florida, why did they have that odd break in the opening?
That's a good question. Do you have any insights to that?
I don't know. Maybe there was a bathroom break. I don't know what that. I don't know why there was a break in the opening. It was a little odd for me.
That was unusual. I would say I was surprised there was a break. I would say I didn't hear any objection or anybody saying it. It sounded like it came from the judge, right? Oh, can I comment on the? I want to comment on the judge too.
Yeah, go ahead. What do you think about that? By the way, his chair is getting a lot of love. People want that chair. They want those blue dimples massaging their back. It's like the best chair ever. But go ahead. What are your thoughts on the judge, Steve?
No, I think the judge. Of course, he did rule poorly on that evidentiary ruling, but that's my pet project, right? But I like the judge. I think he's got a really good bench demeanor. He's very calm. He's a calming force. And I like kind of his down to earth kind of, oh shucks kind of guy demeanor. And they're like, I'm the law. You can't disagree with me on the law, but they're the facts. Use to figure the facts. I love that kind of Southern. I like him so far. I mean, so far he's been good. Now, again, I disagree with his ruling on that, but that's just me.
Well, you're going to disagree with rulings with the judge. You're going to say, that one's not right. We're going to get to objections where like that should have been sustained, right? That's going to happen over the trial. Like I just accept that. I bake that in that at some point I'm going to disagree with the judge. It's sort of like, your armchair reffing it. Right. You're watching the football game. You're like that penalty was called wrong. Got to call that back. You're going to disagree at some point. But the question is, are they, to me, is the judge as a whole, a fair judge? Are they extremely prosecution biased? Are they defense biased? Is there something that as a whole is going one way or another? At this point, it doesn't seem like he's going one way or another in terms of his
and that's what you don't want to. He's not projecting any bias, which is good. It seems like the lawyers respect him in his courtroom, which is good. He's respecting the lawyers in the courtroom, which is good. So, I mean, at this point, I really don't have a criticism of anything about him particularly. And like I said, the only thing so far is I've already got that appellate brief. I'm working on it, right? Point number one, if this guy's convicted, that was wrongfully allowed. But other than that, I mean, I like the judges. I like the courtroom. And it seems like the lawyers are pretty respectful to each other.
So far. Wait till it heats up. See, right now it's easy to be gentlemanly and all Southern. As I say, the Foghorn Leghorn thing. It's easy to do that in the beginning, but when the shit hits the fan, when it's really going down, then we'll see if that Southern mask drops. And I call it a mask because, by the way, it is a mask. Because when I say bless your heart means fuck you. Right?
Exactly.
It does not mean you're a great person. By the way, Steve, you're getting some love here. I want to shout you out here. Ben sent a $1 tip saying, "Hey Steve, love your book. I was even able to understand the big words."
Thank you very much. Yeah, I've had a lot of. The book is not just for lawyers. It is all law. I mean, it's something that a lawyer can rely on and cite to if they need to. However, I've worked my entire life to write cleanly and fairly. I think too many people disguise what is confusion with big words. They try to prove themselves intelligent by talking over your head, when in fact what they really haven't done is worked out things to the bottom level foundationally. Whereas I've worked very much foundationally to move up to try to explain things fundamentally and also offer.
And Steve, to that point, I want to hammer this point to home. Like using big words to prove you're smart is like a short guy saying, "I'm tall. I'm really tall." Like it is the smallest D energy out there ever, period. It is so it's disgusting. Use simple language, have people understand you. It's more convincing that you worked hard to be a good public speaker, to be an effective communicator, because it is hard to be an effective communicator.
Yes.
It is truly hard to do that because people tend to think that you are a good speaker. People tend to think that you're speaking clearly when in fact you're not. It's actually harder to make your language understandable and to take a difficult concept and make it simple. That's something that's difficult.
Exactly. And that's what I've worked very hard doing that. And I think I've achieved that in my writing in this book. And I will always strive for that because it's almost an aggressive posture for somebody to attack you with big words. And then you don't want to say, gee, I don't understand that word because now I feel stupid, right? So keep their mouth shut and they remain confused. But that's an aggressive stance on the part of the speaker. They're not trying to communicate. They're trying to push you around. My purpose is I want you to understand what I'm saying, and I want you to convince you that I'm correct or show you the issue that I'm focused on. Like this science guy, this gun matching thing, right? I'm trying to, what is the question? Like, how do we prove you wrong? That in order for science to be valid, you have to tell me what would prove you wrong. And he can't, the thing is that's not he says, well, my proof is that this other guy that I associate with, that's in the same board, uses the same techniques. Well, he confirmed he has the same opinion as I do. Well, that's, how many people agree with me? Like, here's a guy that agrees with me. Now I'm scientific, I mean, it's stupid.
Right.
It's not science.
I think that some of this stuff that they put out there as science, they need to be very, very careful because the thing is, you're trying to use that imprimatur of this is the science, right? Which is I'm going to say it, fuck it, whatever. This may get me in trouble. It's the Fauci-esque thing, right? We are the science, right? And it comes off as repulsive because we should be able to believe it. You should be able to explain the science. Science should not be something that cannot be reproduced and cannot be explained. Well, people should be able to explain stuff. And the law is the same way. The law should be able to be explained. That's why I enjoy teaching my courses, because I know lawyers, we try to make things sound complicated because we want to gatekeep our profession. And we want to make it sound like we're worth the hundreds of dollars an hour we charge. But let's be honest. Some of these guys, Steve, and I'm working with them, whether they're dirt lawyers, IP lawyers, whatever, they are class A morons, and they're trying to convince you with fancy words, with other bullshit, with degrees, with letters on the wall, that they know better than you and your common sense. But guess what? Your common sense, particularly if you're experienced in the field, may be better than whatever they've learned in law school, than whatever they've, seen, outside of the practical knowledge of the thing. For example, the firearms expert that tells me he's read a lot of books on guns. I trust, Andrew Branca, who's fired guns more about that than I do about this guy professionally.
That was a competitive. That guy's a competitive shooter. I mean, he's a serious shooter. I mean, he competed for years. And did I tell you he showed me he's got a what do they call that?
Whoa! He showed you his piece, Steve?
He showed me his piece.
That's a private thing.
I asked for it because it's
By the way, are we any closer to getting hard? By the way, what's our hard status right now?
No, we are. You've only sold 2 books. At 2 books.
Okay, 2. Got 2. Okay.
All I'm going to do is eat some kimchi for you. Other than that,
that's fine. That's fine. You got to eat at some point, right?
Drink is the drink and kimchi is going to be the 5, and then 10 is to get hard. So far you're just soft, man.
I am pretty flaccid right now, guys. We're living the flaccid mindset right now. By the way, let me give this a quick super chat. Merm said, "Thank you, sir. Off the bed. Still got work tomorrow. Good night, everyone. Good night." And guys, check in for as long as you want to check in. Stay as long as you want to stay.
And actually, in all honesty, I would expect that a lot of your chat is overlapping with Vices and Branca and Ricada.
Oh, yeah.
So I've already sold, like 600 books. So these people already have it. And a lot of people have already said they've read it and they like it. So.
I'm late to the grift. Yeah, I'm late to
You're late to the grift. But anyways, but I appreciate the effort. In fact, I will eat kimchi before we sign off. How's that?
That's good. I like that. Yeah. I appreciate that, throwing that out there. But guys, just as
I've never... Kimchi is just for you because I've never eaten kimchi online. Yes, do that again. I didn't mean to interrupt you. That was wonderful.
Yeah, no, that was good. But no, I mean, I do miss the kimchi when I'm away. I was in Singapore for the last 4 or 5 days, and I was, eating like, Chinese food, Thai food, also there's some Malaysian food, Indonesian food, and I'll remove you for a second while you're talking. But guys, make sure you guys are liked, subscribed. Make sure you guys are checked in with all of that. We're going to be back here every single day covering this period. And also, I'm making sure to get some guests. So I've already confirmed one guest for tomorrow, a layperson. And I am going to get also try to get James from court, who is there. I don't think he was in the courtroom today, but he is going to be he's going to be back in the court next Monday, he says. And he is going to hop on either tomorrow or the next day with me. So you should get James from court, who will be reporting from court on. James is a good guy. Despite the fact that he was in Broward County, he's actually based like secretly. He just can't talk about it that much. We won't tell anybody. But speaking of based and having somebody who advocates books here, we'll bring in a little guy who some of you may know, may not know, Mr. Andrew Bronk.
Hey, there he is. But Andrew doesn't have kimchi. Look at the kimchi there.
It does not, that actually looks really good.
I know. Look at that. That's good stuff right here. I love kimchi. That, Steve?
Yeah. Speaking of which, we already got the memes here. Dick Poon. So Andrew, I know you're running around. You've been busy. Did you have a chance to catch any of the opening, closing? The opening. It's not closing.
No.
Or the prosecution defense.
I hardly know anything about the case at all. I just know some dude. I guess he's charged with killing his wife and adult son.
Yeah, and they keep using South Kakalaki, South Carolina. They keep dropping. It's so funny. They keep dropping. Just because it sounds scary, right? Instead of saying 7.62, they're using saying, the blackout, right? The blackout ammo, the blackout. It's like, this is extremely popular type of ammo.
Maybe
trying
we
to act
should
like he bought an assassination round.
Let's explain what 300 blackout is. 300 blackout is a round. Okay, most AR-15s are 223.
Yes.
But there's this AR versus AK-47, camp
split.
So people say, well, the 223 round is a very small caliber. It's a 22 caliber bullet fired at very high velocity. And so the AK people said, we got bigger bullets, right? So somebody came up with this brilliant idea. We can make the bigger bullet neck up the bullet so that the actual projectile is much higher in density and has it's a more powerful, heavier round. And all they have to do is change out the barrel. You can use the same magazines and everything. And now it's 300 blackout, but it's basically an AR with a little different caliber bullet in it.
Right.
Well, you can get them subsonic is the key. So they're very good to suppress.
Right.
You put a suppressor
you can see
on
it versus 223 right there, right? That's the round difference. Yeah.
And you got a bigger bullet. Bigger is always better, right?
Right. It's just I love how they use words like, and you guys know this, they use words like assault weapon to make it sound scarier, right? Military style rifle to make it sound scarier. And I know why the prosecution would do that, right? Because they're trying to paint him as a cold-blooded murderer, right? And saying that versus the technical name sounds better. I think that's the tactic, but just want to.
It's always the wrong ammo. It's always the wrong gun.
Yeah, right, exactly.
Well, and have you heard about it? Because he's talked about this a little bit, Andrew, but they brought up this matching, the round matching. So, hey, we can trace that this round came from this gun.
It's the shell.
Right?
They said the shell that was ejected. Yeah. They found he had a 300 blackout rifle, and they witnessed somebody shooting the rifle, and the shell casings were being ejected. So they recovered some of these shell casings, and they say those shell casings were ejected by the same exact firearm as the shell casings that were ejected at the murder scene.
Yeah, I think that's bullshit. I mean, there are gross characteristics that tend to be left by, on a make and model basis, but to match it to a specific firearm, I think it's just utter nonsense. There's no controlled studies that demonstrate they're able to do that. They're just making shit up.
Yeah, and it's like, how do you disprove that? What is the test, the scientific test? Okay, you've got this theory that you say is confirmed by your buddy who has the same qualification. How do I disprove you? Oh, well, you can't.
No, if you had 1,000 rifles and 1,000 pieces of brass, same make and model rifle, same caliber brass, they'd never be able to match them up with any reliability. It's just nonsense. But they're never asked to do that, so they can pretend they have the capability.
So what evidence would you like to see? So in its case, and obviously, Bronco, you cover more of self-defense cases where it's an affirmative defense where the shooting is not in question, right? But here we have a shooting that's in question. Did this guy, murk his son and his wife, right? Did he kill them? And what they've both described, by the way, the prosecution and defense described the gory nature of this shooting, brains blown out, blood everywhere. They went through that, a lot of detail, both of them. What would you want to see in terms of evidence to say, hey, this guy did it, other than eyewitness, right? Which we don't have.
I mean, you'd be looking for stuff like, motive, incentive. I mean, those aren't elements of the crime, but there's circumstantial evidence that might be consistent with guilt. If you can match up the, the ammo or the cases as being consistent with the murder weapon, that's powerful evidence. This idea that it's an exact match, that it came from that gun, is ridiculous. But you can generally say, the lands and grooves are the correct numbers, configuration, the firing pin mark on the primer is typical of this firearm. You can say it's consistent with, and then it's like any other killing. I mean, what do they have to go with? Do they have what defense is he raising? Just an alibi defense? It wasn't me. I was someplace else.
I was somewhere else. He's calling up. He's calling us. I was seeing my mom with Alzheimer's. I was over here, doing that. I mean,
right. So, I mean, you have to remember to prove someone guilty beyond a reasonable doubt, you just have to eliminate a reasonable doubt in the minds of the jury. That could be entirely circumstantial evidence.
Right.
Right. And
plenty of people get convicted on nothing but circumstantial evidence all the time.
And that's what I've been saying. I say that with a lot of cases. I'm like, people have been convicted on less. Shit, Steve, you can tell that yourself, right? You've defended cases where people have been convicted on less, right? So is it possible? Is it possible?
This is so painful. You're talking. It's like
it's true,
ripping,
right?
You're ripping scabs off.
But okay, but Steve, is it true?
You don't know what I'm dealing. Yes. Yeah. You don't know what I'm dealing with. Something today, right now, this very moment. You have no clue. Oh my God. The state is trying to exclude exculpatory evidence from our case. It's unbelievable. It's a one witness case, and the witness has said previously that they have lied on against this very person, made lied allegations before. And we have that. They made that statement to the cops under oath, and they lost the audio tape of that. And we're trying to get in like that statement, and they want to keep it out. One witness. There's no evidence, no physical evidence, nothing. So
this notion that you need an actual smoking gun to convict somebody that's just not how the system works.
No.
Yeah, that you need to find the murder weapon with a fingerprint, blood stains everywhere,
I mean, that's nice,
attached to it. Yeah.
If you have it, that's nice, but
a good circumstantial case is look at this guy, the Idaho killer. Seems to be a lot of the evidence against him. It's very strong circumstantial evidence.
Well, it's the thing. It's there's apparently there's a shoe mark. There's a fingerprint on the K-bar.
Well,
right?
that's everything revolves around the DNA on the K-bar button sheath.
And then apparently, I'm being hearing now. This is the most damning, and I think Andrew's going to laugh at this one. I think he was DMing one of them on Instagram. And he may have started to get mad that she wasn't responding to his Instagram DMs. They were like going to another folder because he was interested. That allegedly that may be a piece of evidence.
Can I comment on how much I love kimchi? I have a friend.
It's great.
One of my friends and actually my study partner, first year law school, was from South Korea, Seoul, South Korea. In fact, she became general counsel of Microsoft and she became very successful and is a good friend. I miss her because she lives over in Seattle area and all that corporate world, making all the money, but
and having the government take it away from them.
What's that?
What did you say, Go ahead.
Korean food is fantastic.
It's fantastic. The food is amazing.
Korean barbecue places where you cook it up on the table in front of you. That's a fantastic meal.
It's everywhere. That's the best thing. It's you bring it, you see it, it's cooked in front of you. You're like, there's no doubts about what's in that because I put it on that. It's like whatever seasoning or whatever I want to put on it, I do it myself. So I know what's going into that.
But you have to go to a good one. My friend, when we graduated, she took us out to nice Korean restaurant. And I've been to Korean restaurants. It's like, yeah, it's okay. And man, it was great. It was like it was pickles and these noodles and everything was in this box. It was
the side dishes.
Oh, the side dish is so wonderful.
Side dishes are key. Potentially criminals for $2 says, and I sent him an invite. So Sean, you have an invite. Check your Discord if you want to come on. Tool mark examinations are barely above polygraphs.
Mm-hmm.
Tool mark. When he says tool mark, is he speaking specifically of like any physical item, right? And,
like the marks, the marks that the gun leaves on the brass or leaves on the bullets, and this idea that you can match a specific piece of brass to a specific gun, and they bring these experts in, and I mean, this is it's really horrible. It just shouldn't be allowed because it's presented in this faux scientific manner, and it's never been rigorously scientifically tested.
Right.
And if they could do it, they would test it, and they would show. There would be studies, right? But there's not.
Well, the problem is that when you bring in an expert, like, and this is just in general, perceptively, well, like people trust us on the law for better or for worse, right? They trust us. So when we say something, they rely upon it, right? We're viewed as more reliable. When you bring up somebody and they give these qualifications, they say, I'm a doctor, right? You automatically, as a layperson, you're like, oh, well, I should trust him, right? He's an expert. So I should
well, and all these tool mark examiners are in the same club, so they all talk about, they all go to the same little conventions and take the same training courses, and they all want to protect their little fiefdoms as being these experts. So the only people, it's hard to find people who would argue against them because the people who've gone through the system are all tool mark examiners.
Right. And they all have, and this guy is a perfect example of what we deal with all the time. And that is he has a science degree, a bachelor's degree in some scientific field, which is cool, which is better than I did. I became a lawyer. And then they go to this 2-month-long training where they're given the policy manual and they look through the microscope and they're said, okay, if these striations line up and this striations line up, then this is a match and you can say it. And then they're trained to do this like a little trained person to crank it out. And then they give it to somebody else who's been going through the exact same training. And then they say, it's a match. We all agree. The problem is the foundational basis for the science is not there. Like he is an expert, so he can talk about the firearms operable. It's a 300 blackout. This shells from that. He can testify to all that. It's this matching idea that is not scientifically valid and has not been proven. And it's incumbent on the state to prove beyond a reasonable doubt. And that's why there was that motion. That's why there's built-in error in this case already, because this judge allowed that to be argued at opening. It's going to come in. That guy's going to get up there and he's going to say this shell casing was fired from the same murder weapon. Hey,
speaking of murder weapons, what's going on, Sean?
Hey, Sean.
Not much. How are you guys doing?
Good, man. Good. Appreciate the comment on tool marks. Just dealing with the opening statements. Did you have a chance to watch the opening statement, Sean?
I heard about 5 minutes of it where they talked about the scary 300 blackout, which that is an interesting, that usually doesn't pop up, but the forensic, the tool mark examinations, like if it's a knife or leaving impact, like if it's very obvious, like there's a chunk missing out of this blade and it matches up right, you don't need the expert because it's very clear. When it comes down to like, there's an extraction, okay, well, which gun did this? All they can say is to a degree of certainty it was this type of gun. There's usually
exactly
there usually isn't that clear defect that you can tie to that.
Well, and let's talk about that because is there something called accidentals? And this comes mostly in shoe print evidence, whereas you have a shoe that has a particular wear pattern or a particular mark or stripe.
Well, that's the Idaho case, right? The Vans with the diamond pattern. They're saying the distinct diamond pattern.
Well, talking about the way your sole wears. You wear your
right,
sole.
like
okay.
So yes, you could say those are Vans and those are 9.5, and he wears Vans 9.5, and we found Vans 9.5. Right, all good. But to say that it's a match, you can't do. Now, if there's
the specific shoe.
If there's an accidental, if there's a particular mark on that cuts off on the shoe print, then that can be very distinctive. And that is, but still, I still don't think you should be able to say it's a match. But you can say what Sean has just came in and said, which is a reasonable certitude. Well, you said it.
It's reasonably consistent. Like this exhibit. I've heard it before, where this exhibit's a similar it could be this one, but you can't say it's exactly this one.
Right, but that accidental type stuff is. Somebody in the chat, I forget, a while back.
These are gross characteristics. I mean, you really don't need an expert for that. You could say, hey, here's the print with the piece missing cut out of the heel. Here's the shoe with the identical piece coming out of the heel. You, the jury, can make a reasonable inference. This print was made by the shoe.
Right.
Yeah.
Exactly.
But I was going to say, it also just comes down to a lot of this forensic stuff. Like, even like the FBI, it's like, Steve, you probably heard about this. It was like 8-9 years ago, their hair analysis unit, the DOJ had to admit, like, a lot of this they kind of just make up.
Well, no, they threw out a bunch of cases. But see, this is the thing. We're now in the middle of this tool mark issue. And right now, everybody's like, oh, but this is great science. Well, and then all of a sudden it's not. It's sort of like the bite mark evidence. The bite mark, we convicted somebody, put him in prison for 40 years, and he was exonerated because of the bite mark, because his bite was a match. Well, and he was convicted because the scientist got up there and said, I'm an expert, I'm a dentist, and his bite, that bite mark on the victim, that is a match to his teeth. And he got
a logical fallacy behind these pseudo-scientific methods, because they only look at when they're right, when they're correct.
It's like a drug dog.
That's not how science works. Yep. You have to also be able to demonstrate that you weren't wrong. Like, if you bet me $1,000, I will get a piece of paper and write down for you to 1.1 degree what the highest temperature on the face of the earth will be next year. And I will win that $1,000. You know why? Because I'll write down every temperature from 0 Fahrenheit to 200 Fahrenheit on a piece of paper. And one of those pieces of paper will be the right one. So I'll have predicted it, right?
It's the text bullseye, right? It's the text bullseye. You draw it around.
Yeah. Well, and that's what happens with a lot of these expert type folks, is that they all sit around a conference. They've all been trained. They all think they're really smart, and they don't question the fundamentals of it. And anybody that does is a heretic and is kicked out and is a skeptic and a non-believer, you know. And then it's like, and there's no independent, and it's confirmation bias, because it's like, well, all the people that I've testified for have been convicted, so the jury found them guilty, so they must have been guilty. But they don't account for the fact that people are wrongfully convicted.
And the other thing is the accreditation they go through. It's the National Association of Hair Follicle Examiners. It's run by some guy named Murray in Idaho who does it out of some like dog catcher's office. That I'm the hair examiner here. That's all these guys are. It's just it's resume padding, because otherwise you're like, well, you're not a member of an association. No, like, well, how did you train? Well, remember the guy before me kind of told me.
Brock, remember that expert that we watched on the and he had all those associations that he was
right in the Florida, the Casado immunity hearing.
Right.
It's like, so we were watching this Florida self-defense immunity hearing. The guy got the defense won, they got immunity granted, but the state had brought in this expert who didn't have any actual expertise in the subject matter. But on his website, he had all these associations he joined. And I know some of them, and these are if I sent them $50, I'd be a member of the association too. There's no.
But that makes it valid. That makes him totally valid, Bronco. That means he knows everything because he's in the club, right? He's in the club, and you're not. That means he knows.
It's like becoming a super lawyer.
It's like becoming a super lawyer.
I get it. It's funny.
By the way, okay. Can we let people in on that? Literally, anytime you see a lawyer post that they're a super lawyer, you pay for that. They're like, oh yeah, we're happy to give you this award if you pay us $500, whatever it is, $1,000, whatever the money is. Whatever. I think they do it by locality, right? So
I just got an email like that today at my office, and it's laughed because I'm an assistant public defender. It's like, I don't need this stuff. I don't care if anybody calls me a super lawyer.
Well, you do if you're running for office, right? If you're trying to run for something and you want to say, I was voted super defender for 3 years straight.
I used to be on
such nonsense. I can tell folks I've been doing nothing but use of force law, self-defense law for 30 years. I'm almost certainly the national expert on self-defense law. I've never been a super lawyer. And neither have I.
Yeah. And by the way, that's all you should be required to do. It's like, how long have you done this? What are your results? Like,
if I didn't have to join the Florida bar, I wouldn't be a member of the Florida bar.
Fuck the Florida bar. Steve,
fuck me. They forced me to join it.
I read the other day the paper they put out on VWS where they were talking about the feminist perspective and how we need to, and this is from the Florida bar, right? They put out straight propaganda, right? Run by leftists, run by hardcore feminists that control the Florida bar. Don't even get me started on the women's associations.
Yeah,
they're super woke in a red
have
state.
IOLTA accounts in Florida?
Yeah.
What?
Do they make you do IOLTA accounts?
Oh yeah,
IOLTA.
No,
Where
I don't
you
have
got
I
client
don't.
money, it's got to be stored in a special.
Yeah, which is why I'm always a consultant. Which is why I'm always a consultant. They could
left-wing
suck me.
organizations. Yeah.
Fuck that. No,
Yeah.
it's so stupid.
Oh, Andrew, you can open up what I shared.
Oh yeah. So you shared this one down here. Yeah, got you.
Yeah, so I put this up in my locals. I'm like, yeah, it's not too hard to become a lawyer of distinction. I could join Ben Crump.
Oh shit, 700. You could be a featured or a charter.
Yeah, you get the crystal. You get
Oh,
personalized
God.
crystal.
Oh yeah, they could shove right up your. I mean, this is ridiculous. I mean, this is what it is. It's all bought and paid for. It's all smoke and mirrors. It's all BS. I mean, I'm actually though I am shocked that he can afford this legal team. Like, how do you think they're getting paid, given the fact that?
But see, that's part of the thing though. Is this guy
Yeah.
comes from his family? They've had 3 generations of this guy's family that have been the elected prosecutor since 1920 till only a few years ago. This was the family that controlled the prosecution office in this jurisdiction.
So you're talking about nepotistic connections, not necessarily monetary.
Well, I mean, but evidently this guy's very dirty. I mean,
it translates into money.
Right.
Yeah. Okay.
Yeah, and they said they found him stealing that 8 or 9 million. Well, it probably just didn't stop there or start there. So
No, and
who knows
wealthy people want to be friends with the local prosecutor.
Mhm.
So
True.
Things just happen to go his way.
Yes, he also might have a few favors he called in.
Right.
Oh, and by the way, Bass, thank you for the 1999 super sticker. Appreciate you. And guys, appreciate you guys if you smash a like button on this. If you like seeing people like Steve Gosney, buy his book, Crime Law. Check out that book. Andrew Bronca.
No drinking tonight, man.
I know it's fine. Well, I'm sorry I can't get hard tonight. Even though Bronca's on, I can't get hard even for Bronca. But follow lawofselfdefense.com and obviously Potentially Criminal Sean. These are all good friends of mine. They create amazing content. And Sean, I don't think you have a product to shill yet, but you got to get a product to shill at some point.
Yeah, I need to come up with a new one for Sarah Boone. I'm still trying to figure that out.
I mean, it's luggage. I mean,
I thought about I work with Samsonite and license it out.
Hey, I did get your coffee grounds mug.
Yeah, I saw that. I was trying to see if I could get a way to do like luggage tags, but I'm still trying to figure that out.
Yeah. Let me ask you, Sean, what type of evidence would you like to see from this case, since given that it's going to be mostly circumstantial, or maybe I would say what type of combination of elements would lead you to believe he's guilty? Because I think I said this to Steve. I thought the prosecution did a better job in their opening, but I think they have a tough burden here, especially with the types of evidence they're presenting. But what would you want to see from your?
I mean, without him directly snitching on himself, you're going to need like witnesses in the area who can tie him to the area. It's kind of like with Brian Koberg. You need some of that. Okay, he's here. Why is he here? Okay, well, it's his home, but at the time we think that the mom died and the son died, he was here.
Are they doing that with cell phone tracking?
Yeah, I was gonna say, do they have any cell phone? I mean,
yes. They literally said in the opening, on this cell phone, we're going to show how we got his location. We got him there. We see that he's at that location.
Have they caught him in lies? I mean, did he give statements that are provable?
They posited that they're going to do that. We haven't seen it yet, but they're insinuating that the statements that he gave to police, particularly the statements he gave right after he calls and they show up, the body cam statements, that those are inconsistent.
And is there some kind of motive? Is there money or a lover? Or...
The motive is the difficult thing, actually, because the motive is the thing is, why would he murder his family in the middle of these investigations, these frauds going down at this point? He's got all these other eyes on him. Why would he murder them on top? It seems kind of extraneous. So they're going to have to prove why he would do that.
But all they really need, like I said, you don't need a smoking gun. You need a lot of little building blocks, like Lego blocks, from which you can build a narrative that's consistent with guilt that a jury will buy beyond a reasonable doubt. And it could be false statements. It could be, 300 blackout. It's fairly popular, but it's not super common. So that's a little bit unusual.
But I would say it's not like ultra rare, right? Like some specialty round for some, collectors. A little bit.
If you picked up an AR pattern rifle, 95% of the time or more, you'd expect it to be 223 or 556, not 300 blackout.
But 5% of ARs is still a lot of ARs, you know?
Yeah, but there was only they're spread over the whole world. and you know, he had
the whole world.
Not in Korea.
No, they are. No, they are.
Right.
No, they are. They are in even countries that ban them. I'll say Japan, Korea, whatever. If you really, really, really wanted to, you could get it from the right guy. That's the thing.
Hey, I'll tell you, man, 300 blackout is a great home defense round.
Yeah.
It's a big fat bullet, a lot of energy, and you can suppress it. I mean, it's because it's subsonic.
Yeah. But yeah, it's going to be stuff like that. But for me, juries, they'll convict on far less. So.
Let me ask you guys. This is actually a good one for Bronca and Sean. Like, there's two different murder weapons, right? I think there's the shotgun and there's the AR style rifle. Like, could you come up with a reason why two different weapons would be used on the separate murders, right? So the son was shot with one and the wife was shot with another. Is that something a single individual could do, or you could come up with a motive for?
I didn't know about that. That's
a fact. That's a case fact. So one of them was hit with one and apparently killed with one was killed with another.
Are the weapons actually recovered?
No.
They don't have the weapons?
Well, what about the shotgun? I know that the blackout.
The shotgun might be, but but I think the rifle.
I'm not sure. The rifle definitely is not, because evidently he had three 300 blackouts, and one of them is missing. So they're saying the casing they have the casing that matches the casing supposedly from the murder scene, and but no, and a missing 300 blackout AR from his side. So, and then they also have his alibi is that he went over to his senile mother's house, and the cell phone records are going to be very interesting, because that's going to tell me, to me, that's going to be a very powerful. And sometimes the close cases are the really hard ones for the defense, because juries love to figure things out. They like to puzzle it together like it's a puzzle. And so when they I know what happened here, he did this, and they put together the path, and they don't see that reasonable doubt. It's like a game for them to figure out. So sometimes this is the kind of case that circumstantially could be built. And I think the key thing for the prosecution is to show that cell phone trace, the capability, the mystery missing gun, the fact he's got the blanket that's covered up, that's got the gunshot residue, he's got the motive. His motive supposedly is to divert from all his other financial crimes, that he's got this tragedy and maybe.
And there's somebody brought up a theory about the inheritance. Like, if he kills his wife and one son, then he can go to the son that he likes. I mean,
it's weird. I think that's actually the best defense to me. I would push very hard the fact that no father would murder his son and his wife in this brutal way. I mean, it's bizarre to me. I mean, it's hard for people to comprehend that.
And if it really is two separate guns, that.
But see, if you're planning it, if he really is planning it, though, that's a good little factoid to put on your side.
Yeah, but I think the prosecutor's going to need a lot more than just saying, "See, he's super sneaky." I think that actually sounds like that's helpful, because it's, who would think to do that?
Hey, 2 more books and I
would
get
you
to drink.
oh, nice, very nice, guys. By the way, a lot of people are saying cartel hit. Sean, I know you like the crackpot theories. What do you like do you like cartel hit as a possible theory here? Putting on your tinfoil.
I mean, the problem is when you start talking about the cartel showing up, you better be able to articulate that story to a decent amount. You can't just say, "Oh, it could have been some, evil hitman like an Ozark." You're gonna have to explain why, and then that doesn't end up looking good for Murdaugh. But you could claim "Oh, they were 2 robbers, 2 meth billies." Like, that all makes sense in South Carolina.
Or people that this family has
meth
pissed
billies.
off,
I like that.
That this family's pissed off over their career. They've got they're big, rich, successful, and they're corrupt, and so they have enemies. And
or as a prosecutor, how many people has he put away that might be very pissed off? So
families of the
Well, also people he's borrowed money from potentially, because if he's really caught up in a bunch of land deals bad, and one of them is to some sketchy folks. I mean, I dealt with some folks in Colombia, Venezuela that they got connections. They got an uncle, and he might come through and try to collect on that in the personal way, the same way they collect in Bogota, or Caracas, right?
This is a fascinating case, because it really is there is some reasonable doubt. There's some issues. It's not like cold cut. I mean, we don't know what happened, and we're trying to figure it out, and we're going to have to watch the evidence to figure it out. There's going to be a lot of scientific expert type testimony that's going to put things together. It's circumstantial. There's motive. It's a very unusual hit. Usually, Andrew and I have talked about this a lot. I know, and I'm sure Sean would agree. Most murders are completely senseless. Most murders have no reason, have no real motive.
Just completely just shot a guy
because he didn't like the way he looked. He disrespected me, or just stupid. The stupidity is what it is usually. I mean, it's very unusual to.
I mean, there's a reason. There's a reason, but it's dumb.
Well, but you figuring, I had a triple homicide between the Warlocks motorcycle gang that I did,
right,
and over here in Sanford. Sanford. Three.
Oh, I know Sanford.
There's 2 Warlock gangs. Who knew? 2 Warlock biker gangs, and they shot they were shooting. And at the end, I did 2 of the guys. After the whole case, I couldn't tell you why it happened. It's like
the most common thing in the world is for one dude to shoot another dude over a beef or a slight.
Or a territory, or
an insult happened,
or a woman.
And they're separated now after the insult. There's no reason to be fighting. But the guy who was insulted, he knows his friends are going to call him a bitch for the rest of his life if he doesn't teach that insulter a lesson. And he gets his gun and he goes and shoots him.
Yep.
You can't insult me in front of my brothers.
Well, there's a survival. They have the survival thing on the street. It's all about respect.
Right. Losing face, right? I mean, that's a big one. You've lost face. You made him lose face. You gotta go gain it back, and you've got to kill the guy to do it, right?
Oh yes, so most murders are that way, and that's very hard for families of murder victims to understand because they want to inscribe meaning on the death, and that's why I'm and part of my next book that hopefully it'll be recovered, is that you get meaning from life. How you live your life every day, the choices that you make every day, that's where meaning comes from. We all die. How we die, it doesn't have to have some world-altering meaning. Usually it doesn't. You die of cancer, you get hit by a car, you get murdered, whatever, we're going to die. You don't have to have a mind-altering reason to die. We just do. But how you live your life is what matters. That's what gives life meaning. That's what gives the world a place to live.
Deep thoughts with Steve Gosney. And guys, if you like his deep thoughts, you'll like his book. So check that out.
And 2 more, and I can drown my deep thoughts in
alcohol. Just 2 more, guys. 2 more.
What was that movie? Was it the Shawshank Redemption where the actor Tom, what's his name? I forget his name. He gets convicted for murdering his wife. It wasn't him at all. It was like some master guy. Tim Robbins. That's who it was. Convictions like that happen all the time. The prosecutor basically tells a story to the jury that they find convincing. That's it. That's all it takes.
And to be fair, when you think about with Shawshank, his wife was doinking another guy, and they found him drunk in the car outside with a bottle and a pistol.
Mm-hmm.
How many?
Close enough.
I mean that's how it turns out. The 95 other times this happens.
Yeah, it's just you're close enough. You've got enough. You got enough circumstantial evidence, and they say, "Hey, that's our threshold." And
so how did the opening go for the state? I mean, did the state script out the narrative?
No, I will say this honestly. My take of it, and just looking at it from a pure, if I'm a jury, wipe my legal knowledge, wipe the burdens, wipe all that stuff. Just looking who technically did a better one. I liked and was more persuaded by the prosecution in terms of their style. I think the presentation was better. I think he did a lot of pauses. He took very complex legal things and made them simple. He also started out super high energy. I mean, he started out by going something like bam, bam, making the sounds. And that type of stuff gets people's attention, wakes them up. They're bored as fuck in that courtroom. They are bored to fucking tears in that courtroom.
Yeah, very good.
He came out with the level of energy to engage them. I remembered what he was saying, when he was talking about the gruesomeness of it, when he was talking about the weapons, that was completely engaging. He also talked about reasonable doubt in terms of the prosecution side. The prosecution doesn't have to rule out aliens and, the frogs being gay and the lizard people and, Bohemian Grove. They don't have to rule out every single possibility here, the Clintons. That's not something you have to rule out. It's what is a reasonable doubt. A reasonable doubt is something a reasonable person would have. So they did a good job of presenting that, and they kept it fucking short, Bronca. They kept it short. They didn't sit there and said, we're going to prove it with the evidence. So I expect the closing to be much longer, but I like that style. I like not wasting too much time in the opening.
How long was their opening?
You could do it, I think, 30 minutes. It felt like 30 minutes, even if it was an hour. It felt like 30 minutes.
To a large extent, these openings, it's like pitching a movie script, right? You're trying to get people excited about the story that you're going to be telling them. And when you do that and you get their emotional buy-in from the start, man, that's a strong position to start from.
Well, I'm a little bit less enthusiastic. I said that it's about 60-40 prosecutor. The prosecutor, I think,
which, by the way, Steve, is a lot coming from you as a defender. Like if you say that, I'm like, that's pretty good for the prosecution.
Well, no. I mean, the case we did, Vices and I did that Tampa trial. That prosecutor was excellent. I gave him an A. Well, actually, I gave him a B because he cheated on one thing. But other than that, I mean, his opening and closings were great. He just cheated on one bit of evidence, which he gets minus on. Hey, can I thank Chris, Gardner, Jamie, and Catherine and say I need one more book so I can drink. I really would like to have a nice sidecar because you're doing me a favor here. Would you do me this favor? Would you do me this favor? You seem like a good guy.
He's just a simple Florida lawyer, just a simple public defender in Daytona, the dirty Daytona.
I'll tell you a new story.
I went on the worst date there. The girl that I got so catfished. This girl had done more drugs than any girl I've ever seen in my life. I think I could see the vein that was hit. It was 100% the biggest catfish ever. Was in Daytona Beach.
She didn't bring the filters with her to the date.
No. She brought the tracks and not the right ones, not the one that was found across the street at the racetrack. It was looking fucking rough.
I have a little quick story about a mafia hitman that I prosecuted.
Okay. Oh, go ahead.
Yeah, when I prosecuted, yes, it was funny because I got to talk with him. He was a witness. He was in the witness protection program from the Bonomo crime family, and he took down and he killed. He was convicted of at least 3 murders as a mob hitman, and was in witness protection out here. And he was on the World's Dumbest Criminals because he got into this. He had a Goomba's Pizzeria. His name was Joey Calco, and they named his name Joey Milano. And so I got to talk to him. It was funny because he wouldn't take my deal. And my deal was 10 years. And like on this gun charge and this ag assault charge he hit somebody with a gun, pistol whipped him on video. And the best I could do was 10 years. So my big boss said 10 years is the lowest you can go. So I said 10 years. And he's like, and so and the public defender was a buddy of mine, but she couldn't convince him to take the 10. And so she says, would you come talk to him? So I sat in a room with him for about 20 minutes while he looks me in the eye. And he was really very likable, but he was right out of a comic book. He was like, would you do me this favor? Would you do this? You seem like a good guy. I'm a good guy. Just give me 8 years. Come on, you could do that. And it was so funny. He was like right out of a comic book. I was like, you seem like a decent killer, right? A triple homicide murder. But I mean, I got, if I give you the deal, I'd lose my job, so I can only do 10. He's like, he spatted his eyes. He was a character. I kind of enjoyed him. So it's funny. People don't realize that a lot of these guys can be very likable. Mm-hmm. When you represent. I mean, Sean, you've probably dealt with that. I mean, people don't realize. Criminals are very likable. It's like, well, how did you steal that 100,000? Didn't you know? It's like, no, the guy was charming as hell. You wouldn't give your money to somebody that you didn't like.
Yeah,
right?
No, yeah. And in another life, these guys would be, selling you a house instead of breaking into it.
Yep.
they're that good with it. They have all the things that you people go pay Tony Robbins to learn about, and they've already got half that.
Very good at manipulating people.
Yeah, a lot. Yes, and a lot of squandered talent.
And last squandered.
Mm-hmm.
The last.
They could have been lawyers instead. They could have been lawyers
running companies, doing all kinds of stuff.
Well, I also
they're just lazy. They're just lazy. They want the money, but they don't want to do the work. And they're good enough at manipulating people in situations that they can get the money through unethical, illegal means without having to do the work. Until inevitably they get caught and caught again and caught again and caught again. And that's how you end up with, a 40-year-old career criminal who's spent a quarter of his life in prison a couple of years at a time, but doesn't actually know how to do anything except commit crime.
Well, he's a subject matter expert for crime.
He is.
you know, he's
We had
developed that specialty.
We had a case with what was it? I classified the blood gang too in our county. We had a mini blood gang. I don't know how much it was associated with the real Bloods, but they had a little club and they called it the Bloods. And there was like 15, 20 people. It was not an insignificant gang. And that guy, the leader of the blood gang, what was his name? Brandon Washington. I prosecuted him like multiple times. And eventually he's in prison for life for accessory to murder, for planning a murder. And we had a picture in our prosecutor's office of him sitting on the chief prosecutor's lap, being Santa Claus, and he's on the little kid. He's a little kid, and he was like, "What do you want for Christmas?" And we had the prosecutor. My boss was the Santa, and this is Mr. Blood Gang on his knee at like 6, 8 years old. And then later on, he was actually quite a smart guy. It's like he could have been a car salesman. He had charisma. He had leadership qualities. There was something there. And it's like such a tragedy that they throw their lives away. And this is the worst part about criminal law is you see people that have potential that just squander it. And I think what Andrew said
I
is
blame
right.
the women.
Well, a lot of it's lazy.
Hey, listen, that's 100% facts, Bronco.
These guys learn quick. You get more women as a gangster than you do as a car salesman.
Oh, everybody.
You have more money too, and also
everybody's
like being bad, right?
Everybody was so fascinated by the gang because they had a gang code book and a gang like manual, and everybody's like, "Ooh, it's cool." It's like misspelled words, incomplete sentences, crayon. It was ridiculous. I'm like, this is gang. We're flashing the gang symbol. What's the gang symbol? I'm like, it's stupidity. It's nothing.
Convicted felons have 3 to 4 times as many people as many children as law-abiding men.
Yep, hybristophilia. Google that shit. Google hybristophilia. It's a thing.
Women love it.
Hey.
By the way, Steve. By the way, hold on.
I know.
And you've already been memed.
Sidecar.
All right, let me take a break. I'll go fix one. Thank you.
Okay, yeah,
Thank
you go do that.
I can even say, let me see. It was actually there's 2. I'll say
no doxing.
Yeah. Thank you, Brenda, and thank you, Esprit. That's an interesting name. I've never heard of Esprit. That's a beautiful name. It always reminded me of the Lotus Turbo Esprit. Remember that car? It was the James Bond car that went into the water.
Oh yeah.
Oh yes, yeah.
All right, thank you very much for the 2. So hold on, let me go.
Yeah, no problem.
I'm ready, man.
He talked to the audience and had Tic Tacs. Wait, what the? Who had Tic Tacs? Murdaugh? Murdaugh had Tic Tacs? Anyway, also said, family corrupt. He was just dumb enough to get caught. He ruined his legacy is subjective. I was a juror 2 months ago. Opening, prosecution 8 out of 10, defense 4 out of 10. I think those are fair rankings. I don't think Dick Poon bombed it. I've seen way worse defense openings, but I think the prosecution was just better.
What? I saw like 5 minutes of prosecution.
Dick Poon. That's his thing. It's like Harpoonlian or whatever, but and it's calling him Dick Poon. Richard Harpoonlian.
And this is the defense attorney.
Yeah, his name is Dick Poon. He's the state senator.
Why did I fucking miss this? This is
I mean, no, I'm sorry. Like it just sorry that's the way it's gonna go on my channel. Other people are gonna try to keep it classy.
That's awesome.
Be like Richard, the defense Richard. I'm like, no, his name is Dick Poon, right? Like you 100% go by that. I had a guy in my law school. His name was Richard Eagles. He went by Dick Eagles. That's the name you go with.
I would go by Dick Poon. I'd put that on a billboard.
Yeah, and he would win elections, by the way, in South Carolina. Senator Dick Harpootlian. Senator Dick Harpootlian. I'm sorry, that is Dick Poon. Guys. So listen, Sean, what are you covering? What are you doing lately? I just want to make sure you get a significant grift in here.
No, I appreciate it. Yeah, I just put it out today. It took a fucking forever to put together. It's about Logan Paul and why I think he's a piece of shit scumbag, and it's there are other people out there that think he's already cut a deal with the feds for his NFT scam he was running.
Yeah, crypto.
I think
Is this the fighter?
Yeah,
they
Logan
both
Paul.
fight.
Yeah.
They both fight. He fought this guy. This one fought Floyd Mayweather.
So can you give me a TLDR on why is it so much different? Because here's my thing as a person who, because I know there's a lot of boomers out there and people who don't understand crypto. Like, there's a lot of scams in crypto. There were a lot of people who got excited about things, who invested in NFTs, right? You may have bought some stupid looking 8-bit ape and thought it was going to go to 1 million. Like, how is this different than every other NFT scam or every other crypto pump and dump out there? How is it different categorically?
Well, it's different. I think just the profile of the person involved.
Okay.
But that said, though, him and his brother, they have a history between them of pump and dumping these NFTs and crypto coins. So
that's different. See, that's different. Right?
Yeah. And the thing for Logan is he went from this first one called Dink Doink to this Crypto Zoo. And then because I went and found some of his fucking podcasts where he talks about it, you know, in the middle of all this bullshit happening in 2021, by like February 20, it's, you know, August 2021, we're going to launch this. By February 2022, he's like, I spent the past like 6 months. You couldn't get a hold of me. I was doing this other new project. And in the middle of it, he basically, and now he's trying to say like, oh, I was in a dark spot. But he's like, no, the past 6 months, I've been taking pictures of smoking weed and driving cars. And you haven't been able to get a hold of me. And he's like, here's my new NFT project, which it appears it's actually working and it's making a ton of money. And I just brought up like, hey, maybe you could make all these people whole. And it's like, well, of course not, because you're a fucking scumbag. And then he comes out with saying, look, there's like $7 million missing, but I'll give like a handful of the people involved a little bit of your money back. And then that's it. I mean, it's just the whole thing. Everything he's done makes him, you know, and I think he's too stupid to have gotten involved with the government in time to save his ass. So
I think that's the thing that comes out with everybody. Are they a Fed? Like immediately, it's like they've gone over to the Feds.
He should have gone to the Feds immediately, but I don't. You know, even if he did, though, you're gonna have to sit there and explain to a U.S. attorney, like, "Hey, here's this thing I put together. It's totally not a pyramid scheme," but then these other guys rip me off. Like, you know,
I think Attorney Tom is going to arbitrate the shit out of him.
Oh yeah, well, and I point out that Tom's already going after him, and
yeah,
well, you know, that's scary enough. You know, getting convicted of wire fraud, and then I think it's not just like wire fraud, but you know, that's
a lot of time, man. That's a lot.
It's security. It's securities law because they haven't really proven with crypto that they've left that wide open to fuck people on.
Well, right now it's commodities fraud on them, I think, but the bigger issue is it's like when you
have a commodity.
Yeah, technically it's a commodity. I mean, it's
no. I think only Bitcoin and maybe Ethereum are commodities. I think the rest are securities.
It may be, but I mentioned SEC might get involved, but for right now, even if it's just commodities fraud, that's bad. But the bigger thing is, and I put it down because I was, you know, most people hadn't thought about it. What do you do when you have all this money? Well, you're going to launder it, then you're going to structure it, and then you're not going to pay taxes on it. So it's like, boom, boom, boom. He's got those probably coming too. So,
by the way, we have a good.
Once people start looking,
yeah.
Oh, I don't like my hair. I don't want a pink hair.
I like
why not? Why not? I think you would look good. Yeah, and I think the cowboy hat does
John
look
Dutton style.
Go put it back.
The problem with all these grifts is you
can
get away with it for a long time, but once the can opener comes out and they start opening stuff up and start looking around, they find everything.
Well, and Bronk, I don't know if you heard this, but the Paul brothers, because they're twins, they have between them like 5 or 6 pump and dumps for cryptocurrency between them.
And now, Sean, that's the thing. If it was 1 or 2, like that they got involved in, because everyone during crypto had their, you know, it was a grift, and you know, a lot of people got into it. A lot of people made money and lost money. Right? Yeah, we should start Lawcoin, right? Like it's like Chris Boozy.
That's a good idea.
You know, it's like a super chat. You know, except for we give you nothing for it. Yeah, I mean, it'd be fine. Everybody got into it. If you say, hey, I was involved in one, I shilled one. Afterwards, I realized NFTs are trash and they're not worth anything. You know, I learned my lesson. Bye. But if you've got a history of doing it, honestly, that makes it way worse. Because then you've seen it happen. You've seen the pump and the dump and that.
Yes, and when you jump mid-project is the worst, I think.
And presumably other people are involved too. So the feds grab them by the nuts, give them a squeeze. Those people start talking. I mean, it's the whole house of cards comes down.
Yeah, and this is the part I pointed out. In the aftermath of FTX, Logan Paul is such a juicy target compared to the programmer. You know, him and SBF are 2 good scalps to put on your wall.
Well, this is my tinfoil is I think they'd rather, you know, it's much flashier to go after Logan Paul than it is for SBF. I think they would love to take the attention off of SBF, you know, especially given that they just, you know, refunded that whole war that was, you know, kind of being used for
the smart criminals, no one even knows their names.
Yes.
It's these dummies with a high profile that make themselves attractive targets for prosecution. Even
unless their name is Pelosi.
Yeah. I mean, but if they're but hold on, they can get off if they're defended by. Dick Poon.
Dick Poon.
Dick
yeah.
Poon, attorney at law.
I missed that.
By the way, hey, cheers to you, Steve. Appreciate you coming on. Number one, first time on the channel. So I'll cheers to that and cheers to $5. You got me like a half chub, right? I didn't get. Did I earn the hard? Did I get hard? Are you gonna give me hard?
No. Wait a second. You got 6 books, so 4 more, and you can get hard. But I don't know if you can do 4 more. I don't know how much longer we got here.
I don't know how longer I can go. It's 8:30 a.m. in here in Seoul. It's rough. I'm on day drinking. It's horrible. It's horrible.
I do drink like a girl. It's a girl drink, and see how this is how much pancreatic destruction you're achieving here. Not only is this super sweet, it's a third Cointreau, 1/3 Fundador brandy, 1/3 Rose's sweet and sour, with a honey sugar rim.
Ooh,
so that's like
the manliest drink you could possibly have.
Really? No, I think it's as girly as
a stroke.
Here you go. There you go. That's a good one for you. Let me tell you about Midget Coin.
Oh,
Poor
by the way,
Trinity
Andrew,
Tom.
I need to get in touch. I need to work out a time with you for the thing I DM'd you about for Twitter.
Okay.
so-
Yes. DM me, and we'll
No,
talk about
Bronca,
it.
not you. Sorry.
Oh, fuck you too, Sean. No, I'm joking. I love you.
I'll send you a DM. I'll send you a good one.
Yeah. I want a spicy DM. I want a spicy DM.
Just don't open it up at work
I try not
or in
to.
front of children.
I've heard this rumor too. Someone said that
Yes,
they
it's
took
true.
down his
True.
grandpa's portrait.
Yes.
What
His
was it in the
portrait-
courtroom?
Yep.
Are you
Wow.
fucking kidding me right now?
Yep. Nope.
What a
That's right.
crazy world.
This is
I
how you
know.
conflict everybody out. Have you heard of it?
Well-
Well, have you looked up there?
Here's issue number 2 on appeal. Why this case was not transferred out of this jurisdiction, I have no clue.
I
Now-
thought it was transferred to a neighboring county, but both counties,
Was
I
it?
think, had very low populations, like under 35K.
Yeah, very small towns, and evidently
Yeah.
they ran this county. It's like this old small town thing,
Right.
and this family goes back way back, and them's good folk, right? So you got. Oh, I want to make a little defense of us Southerners, all right? And even though I'm Floridian, I really am part Southerner because my
Parts
family's
of Florida are the South. Parts of Florida.
Yes, my family's from
Well,
I
big
have
parts.
family from DeLand or D-Land. You know where D-Land is, legal?
Oh yeah, I know where the land is.
Okay, so that's south. That counts. So anyways, just because you speak slowly does not mean you're stupid. And just because you're polite doesn't mean you aren't like a rabid fox. Okay.
Right.
So this is a lot of Yankees come down there and they talk so and they're so polite and they think that they're stupid and they're not ferocious. Boy, I mean, they can tear you apart with a kind gesture. You know what I'm saying?
Especially if you're on the wrong end. That's the thing. Once you get on the wrong end of a Southerner, like you got to watch out. Once you actually piss them off.
And you think you said that, bless your little heart.
Bless your
what
little
is-
heart. It is
that
go
is-
fuck yourself. It is 100% a go fuck yourself.
Right.
Yeah.
So anyway, so that's
Oh my God. Sorry, we had a Southerner say, I speak slowly because them damn Yankees don't understand common sense. You know what? I think that's a good place to end up because I got to get some breakfast here. We're 4 hours in. But I want to thank my guests here, Steve Gosney, potentially criminal, law of self-defense. Guys, we'll be back tomorrow. I'll be taking over once again for Legal Vices around lunchtime. So I'm going to step in, get a debriefing from him. We're going to take over. We should go right into witnesses tomorrow. We're going to be seeing some body cam footage, prosecution witnesses. This is a 3-week trial, so I expect at least a week to be, at least this week specifically, to be the prosecution before we get to the defense.
well,
And it's in South Carolina, right? So Eastern time, probably.
South Carolina Eastern time. So we're on Eastern time. It should start at 9:30 a.m. The judge.
And I think you need to.
dismissed till 9:30.
Can I also just for plugging purposes? By the way, I
Sure.
got one more. Thank you very. What is it, Colleen?
Okay.
Conlon. But the thing is that you need to tune in for the first witness should be the best witness for the state. I would say they need to come out with a bang with their best, the first and last witnesses. So if you're interested in this trial, definitely tune in. Definitely tune in. I'm a lightweight, you know that.
It's all good.
To tune in tomorrow at 9 o'clock. It says it starts.
Yes, 9:30 a.m.
Well, Andrew, send me an invite. I'll see if I can join you guys.
Yeah, and I'll send all you guys an invite and pop on, pop off as needed. I trust you guys. I like you guys. I'm bringing in people only I like and I like hanging out with, and all you guys are on that list.
By the way,
Paul
just hey, wait, stop.
Okay,
Paul just made it 4. You get one more and you're hard.
Okay, guys, before we cut it, we're gonna cut it, but let me get one more time. We'll shill this book over here. Steve Gosney's website. Ideas and Answers in Law, Solutions to Common Problems Confronting the Criminal Lawyer. I'm going to copy paste this.
Yeah,
who wrote that forward? This guy by attorney Andrew Branca, because he is postulating that he is an attorney. Go look up this book, 2nd edition, posted here. It's only $25. Guys, listen, you pay for a lot of stuff at $25. You waste your money. You go to Target, you turn around, you spend $100. Guys, this is great factual knowledge from an actual lawyer, an actual Florida lawyer, a Florida man, and a lawyer. What a rare combination.
And you can get it's available not only international shipping, but also this place called ISBN Services. They made it into like a Kindle book. So it is available in electronic format. He donated that to me. It was so kind. So if you want the electronic version, it's available in 3. I don't know anything about that. I don't understand that whole Kindle
you got to get on that Grift. That is Steve. I only read ebooks. See, you're booming with that, brother.
Well, I'll send you the ebook. That's okay.
Yeah, well, you're booming with that. I only read those.
Okay, well, I'm a boomer.
No, I want to be hard too, but I mean, send me the ebook. I'll actually read the ebook. I'll just hold the hard thing in my hands to show.
So hold the hard thing. You heard it here first.
Yes.
Legal Mindset will hold the hard thing in his hand.
I literally do my channel specifically for people to clip me out of context because I know it's glorious. Sean, go check out his Logan Paul video, Potentially Criminal. Get that thing liked out into oblivion. It's a great thing. It needs to be exposed. People are out there. They're scamming people. They're doing it repeatedly. They're doing it knowingly, and they need to be called out for that bullshit.
Yeah.
And then Andrew Branca, you guys know him. He's got no tie on. He doesn't give a fuck, but he does give a fuck. You go and you get protected. Lawofselfdefense.com. Check him out. He is the self-defense expert in these United States. So check him out over there on that channel.
But not a super lawyer.
Not a super lawyer. Until then, take care.
Peace.